what?
For the assault.
There was 2 assaults.
It was a bad idea to bring back her ex.
They were telling me to get off the property.
Did you pay any rent?
No, I wasn't asked to pay any rent.
Ultimately, you were asked to leave.
Then he left her bloodied.
How did she cut her arm, Mr. Simple? How did she cut her arm?
Daniel pushed me.
This is Judge Judy. Cherie Zarate is suing her ex-boyfriend, Daniel Seipel, for rent and utilities, property damage, and an assault.
Judge's case number 96 on the calendar in the matter of Zarate versus Seipel. Parties have been sworn in.
Thank you. Miss Zarate, you and the defendant know each other, according to you, for well over a decade. And there was a time, according to you, that he was your boyfriend.
Yes, for sure.
When was he your boyfriend?
2007 to 2008.
Are you currently married?
No.
Who do you live with?
I live with myself, and I have a house tenant at the house that I'm at.
Is that your house?
Yes.
When did the defendant become incarcerated? In what year?
It was May of 2019.
You were no longer involved with him romantically. Did you maintain a friendship with him?
Yes.
Just friends or more than friends?
Just friends.
According to you, when the defendant was released from jail, you and your brother owned a house.
Yes.
That another brother had lived in who recently passed away.
Yes.
And you and your brother, or you, made an agreement with the defendant that he could live in the house and pay either $400 a month or rehab the house because the house needed a lot of work because the house was in bad condition.
Right.
That's what she says. Just a second. And your lawsuit asks for $5,000 because you say he did not do anything in the house.
Right.
He did not do work in the house.
Right.
He did not pay rent.
Right.
And he assaulted you.
Yes.
That's what your case is about.
Yes.
Okay. Have I pretty well rounded out what your case is about?
Yes.
Yes. Now, let's deal with the assault first, sir.
Okay.
You were living in the house for a while, over a year.
Yes. Yes.
You were living in the house for over a year.
Yes.
And you paid no rent.
I was not, that wasn't the agreement.
Just a second. Just answer my questions. Did you pay any rent?
No, I wasn't asked to pay any rent.
That you weren't asked to pay any rent? I'm asking you these questions because I have an objective. So you lived in the house for a year. Ultimately, you were asked to leave.
Yes.
And there was an altercation involving the plaintiff. We're dealing with just the assault now.
Yes.
Yes. And the plaintiff, in addition to having the police there, filed for a protective order against you.
Yes.
And that case went before a judge.
Correct.
And you were present.
Yes. Went to court.
Did you have a trial?
Yes.
Did you testify?
Well,
he said yes or no. Did you testify?
No.
Did you consent to her having an order of protection?
I'm not aware of that. No.
Do you know whether she got an order of protection?
I was told, but I was never served. I was in jail. I was taken to jail.
You were in jail for what?
For the assault.
Right. Do you have a copy of the protective order?
Yes.
May I see it, please? Okay, so the proceeding was not for an assault, it was for harassment. Is that right?
It was for both.
I don't see anything about an assault there.
Okay, there was 2. One was on November 11th. And when they arrested him the second time, the police officer told me to go file for another restraining order, limiting him more.
No, just a second. The assault that you refer to in your complaint
It was August 29th.
was on August 29th.
Right.
That's it. Do you have photographs of your injuries as a result of that?
Yes.
I'd like to see them. How did she cut her arm, Mr. Simple?
They were coming at me, her and the Beverly girl, and I pushed them in an open hand, and she fell against a stereo.
Okay. How did you cut your hand?
Daniel pushed me. After he pushed Beverly.
Okay, and what were you doing with him on that day?
Beverly and I confronted him about not paying anything since April and having his stuff all over my property. And I got a letter from code enforcement saying that they were going to fine me $500 a day if he didn't clean up the stuff from my yard. And
because he brought a whole bunch of stuff from your yard.
Yes.
Would you show me a photograph of your yard?
Oh, yes.
May I see it, please?
And there's another. I'm sorry. That's the motorhome I stay in because the house needed to.
So you stay in the mobile home on the property?
Yes.
Well, whose bicycle is that?
All that stuff is Daniel's. Everything in the yard.
What about the lumber?
That's Daniel's. All of that is Daniel's. Everything.
You mean he got out of... Is that all your stuff?
That's material that I brought there to work on the house. That is my bicycle.
Well,
yes.
the lumber. I mean, he didn't get out of jail and they didn't give him lumber. They give you $1 to go on a bus. They don't give you stacks of lumber. So evidently he bought that, but he didn't use it inside the house.
Right.
You live in the trailer behind with a friend.
No,
is that right?
Myself. I lived in by myself.
You lived there by yourself?
Yes, in the motorhome, yes.
Yeah. When Daniel was in the house during that year that he was there and you were living in the motorhome, he was living in the house?
Yes.
Did you ever have dinner together?
No.
No?
Yes, we did.
Did you ever have dinner together?
Yes.
Did you ever have more than dinner?
No. Conversation? No.
Just conversation?
Conversation. I bought materials for the house to fix it up.
Yeah, well, it looks awful, and you wouldn't be living in a motorhome if you could live in the house. Okay. You pushed her, sir, and another judge, not another person who has the same quantum of proof that I would have to if I heard this case, found that she was entitled to a protective order. And you're not allowed to put your hands on it. It has to be compensated then. Yeah. Now, do you drink?
On occasion.
Sometimes?
On occasion, sometimes, yes.
On occasion?
Yes.
More often than not?
No.
Okay. Now, how long did you live in the house without paying rent?
It was a year. I knew nothing about paying any rent.
When she told you to move out because you weren't doing your end of the bargain, how long did you stay in the house after she told you to move out?
I left. I was arrested the next day. When they told me to move out, that's when they came at me and I pushed them away.
That's August.
They
and then
were
you moved
telling
out.
me to get off the property.
Just a second. Just a second. They told you in August. Did you move out in August?
Yeah.
Did you move out in August? Did you ever come back?
Occasionally. I would come back and try to get some of my stuff. I had a stay-away order, so I had to take a police officer over there to get my stuff. All my stuff that I bought for the house, the materials, supplies to fix the water leak in the house, is still there.
Well, a lot of that stuff is just junk.
No, this is brand new stuff. Still
That's in the
box.
backyard. No, a lot of the stuff that she just showed me was junk. Well, the bicycles look like junk.
Okay,
I don't know whose they belong to.
That was something that was brought in there before I started getting the water leak fixed in the house.
Okay.
Damages, she said, was a drywall in the house, but it had a water leak and I had to fix. I bought the...
Let me explain something to you. I don't believe that he owes you any rent. Somebody that you knew, you made a ridiculous arrangement with him, but he does owe you for this assault. Other than this cut on your arm, because I don't think he has a right to put his hands on you when you tell him to leave. Other than this cut, did you receive any medical treatment for your injury?
No.
Okay. Who is living in the house now?
No one right now.
And you're not living in the trailer either?
No, I'm in the motorhome. I'm still in the motorhome.
You're in the motorhome?
Yes, because the house still needs fixing.
And where is your brother? Of course. Where is your brother?
My brother lives in L.A. right now, but he's coming out in a few months to live at the house.
Well, somebody better fix it up.
Yes.
Judge Judy continues in a moment. And later today.
You opened your car door. You weren't looking where you were going. Didn't even look. Didn't even look. Opened the car door. Didn't even look.
Cherie Zarate says ex-boyfriend Daniel Seipel owes for rent and utilities, property damage, and for injuries she suffered during an assault.
All right, I'm awarding you $1,500 for the injury that you sustained. He doesn't have the right to put his hands on you. Sir, where are you living now?
Where am I living? Yes.
Do you pay rent?
No.
Good for you. Okay, we're done. Thank you very much.
All right, thank you, Your Honor.
This case is concluded. Parties are excused.
They were coming at me, telling me to get off the property, that I owed them money.
When he pushed my friend Beverly and myself,
That wasn't the agreement. I was never supposed to pay any rent.
he was just bringing junk and dumping it in my yard.
Well, she didn't want to hear anything that I'd bought materials to fix the problem in the house.
I've been slowly fixing it myself.
I just got the materials to work and they said, get out.
I think he's a hoarder. He just collects things.
It was aggressive, yes.
Just harassment, and I didn't want to have to be calling the police every other day.
Not to do it again.
I'm just glad that he's finally out of my life.
And now, the next case.
All parties in the matter of Koska versus Zurati. Step forward.
23-year-old Brittany Koska is suing fellow motorist, 22-year-old Sabrina Zerati, for damage to her car caused by an accident in a university parking lot.
Oh, my goodness. That is a familiar scenario. Okay. P, that would be you. It's pulling into a spot.
Correct.
When were you pulling into the parking spot?
It was on February 14th at 7:45 a.m.
Where were you going?
Cal Poly Pomona.
To school. And you?
School. Same school.
Okay.
As I was pulling in, I was halfway into the parking spot when she swung her door open and hit my front bumper. As I got out of the car, she got out of the car and indicated she was sorry she didn't see me. Therefore, I thought she knew she was guilty because that's a guilty comment. So then I asked for her insurance information. She said she didn't find herself at fault and would like to discuss it with her father. She walked away from the scene. As I called the police, I texted her saying I called the cops.
Okay, then she came out.
Yeah.
That's what it is. And she says, Ms. Sarita, you say, go ahead.
So, what her statement is actually incorrect, Your Honor.
No,
my door was
just tell
already
me. I'm
open.
listening to your story.
Okay, so my door was actually already ajar. It was partially open.
Show me how ajar with your hands. Look at
So this is my vehicle. I was about this open in my parking spot still. And she pulled, there's an empty spot next to me. She pulls in, obviously in a hurry, and she hits my car. She impacted it. So we get out of the car, and I've never been in such a situation. So I ask, okay, what should we do? She's like, just give me your information.
Okay. I don't care about the information back and forth. So you say that your door was partially ajar. I'd like to see the damage to your car.
Okay.
Was there any damage to your car?
No. The door's steel. The bumper's plastic, so...
Well, if she were going fast, then what would have happened is come off if she hit your car door.
It's kind of hard to see since the car is black, but it was fine.
Okay, so I have a couple of questions now. If you're pulling into a parking space and you're being vigilant about what's around you,
Correct.
and you see the defendant's car,
Correct.
did you see her in the car?
I did see her in the driver's side.
If you saw her in the car, you knew she was getting either in or out, right?
Right.
So you had a 50-50 shot whether she was getting in her car or out of the car.
No, that's incorrect because
Sure
since
it is.
we're at school...
She couldn't have been going up or down. She had to be going in or out.
Correct.
Or sideways.
Judge Judy continues in a moment.
Were you covered at the time for liability?
I didn't realize, but it was lapsed.
So the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you'd had lapsed insurance, it means you didn't have insurance.
Correct.
Don't say it was lapsed again.
Real cases, real people. Judge Judy. Brittany Koska says fellow motor just as she was pulling into a parking space next to her. She is suing for the cost to fix her vehicle.
Now, what you're supposed to do is, when I'm driving and I see a passenger, you know, I'm driving down a traffic lane and I see somebody in a car, I'm saying to myself, are they going to get out of that car? So I'm going to slow down and be really vigilant until I pass them to see what they're doing. That's just common sense. Now, she was almost in that spot.
She actually wasn't, Your Honor.
Sure she was. She had to have been. You didn't say that that's not how the accident happened. You're not saying that that's not what...
My door was already open, Your Honor, and she pulled in.
Listen to me.
And she hit my parked car.
No. No, you keep saying that over and over again. What I'm telling you is that when you got out of the car, you weren't being vigilant enough.
I don't have eyes behind my head.
Oh, just a second. Well, you're supposed to. You're supposed to
She
be
was
able to
obviously
look
in a hurry,
out.
Your Honor. She was obviously in a hurry because she wouldn't have hit my car.
Yeah.
She didn't even want to exchange information because she was in such a hurry.
I think that you both weren't being terribly careful. Do you have insurance?
Yes, I do.
Were you covered at the time for liability?
I didn't realize, but you're
Have insurance.
correct. However, it wasn't my fault, so...
Just the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you had lapsed insurance, it means you didn't have insurance.
Correct.
Don't say it was lapsed again. You didn't have it. I didn't say you never had it. You didn't have insurance.
Correct.
Do you have insurance?
Yes.
You have liability insurance.
Yes. I don't even think she's on the insurance because her name's not on the insurance card.
Name doesn't have to be on the insurance card.
Just want to make sure.
The car has to have insurance.
Correct.
Your car had no insurance. However, I do think that you were partially responsible for this accident. I think that you were probably not vigilant enough and not careful enough. So was she, because she got out of the car, and whether she kicked the car. What kind of car do you have, by the way?
I have a Honda.
When you say my door was partially open, when you usually partially open a door, it's because you're doing something. If you're getting out of a car door,
I
you
was
usually
reaching
either
over to
get
get
out.
my belongings.
Oh, just a
and
second.
about to get
Hold
out.
on a second. So you were reaching over.
My
to the
door was already
passenger
opened.
side. You were reaching over. No, I don't believe. If she hit your car that way, it would have taken your door off.
It wasn't all the way open. She hit the edge of it.
You're sealing it for yourself. You opened the door partially to let some air in the car. You turned off the car.
It was
It's getting. You don't realize where you're going.
Judge Judy continues in a moment.
I want you to go step by step with me. You turned your car off.
I reached over to get my belongings. My door was already open.
No. I don't want you to say my door was already open. It didn't
Okay, I
open
turned
by
my
itself.
car off.
You
I
turned
opened my door.
Slowly.
Closed captioning sponsored by. Are you the victim of a scam? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay, so you turned your car off. I want you to go step by step with me. You turned your car off.
Turned my car off. I took my keys out of the ignition. I reached over to get my belongings. My door was already open.
No. I don't want you to say my door was already open. It didn't
Okay, I
open
turned
by
my
itself.
car off.
You
I
turned,
opened my door.
You turned the car off.
Correct.
Step by step. You turned the car off.
Right. I set my keys down.
You set your keys down where?
On top of my purse. In my
On
purse.
top of your purse,
I
which was
opened
where?
my door.
On top of your purse, which was where?
On the passenger side.
Where your books were and your pocketbook, right?
Correct.
And then slowly, you took the key out of the ignition, you put it on top of your purse, you reached over.
Opened my door. I set my keys down in my purse, on top of my purse. I opened my door, and then I leaned down to get my books, and that's when she impacted my car.
No, didn't happen that way at all.
Okay.
No way. No way. I actually believe you. She's not telling me the truth. You have an estimate to fix your car?
I do.
That's not what happened.
Either way, she hit a parked car.
No. You opened your car door. You weren't looking where you were going. Got your things, took the keys out of the ignition. I believe that. Bent down to pick up your stuff. Believe that. Didn't even look. Didn't even look. Opened the car door. Didn't even look. That's what you did. Judgment for the plaintiff in the amount of $25.65. Thank you. That's all.
Why is that excuse? You may step out.
Judge Judy continues in a moment. And on the next Judge Judy. The landlord who never left.
You slept in the laundry room next door to his apartment. That's ridiculous. You're a scammer and a fraudster.
Next Judge Judy.
She had her sunglasses on, 7 a.m. in the morning.
Usually when it's sunny, I wear my sunglasses or not. I could see if I didn't have my sunglasses on. Maybe that would distract me.
She obviously was going really fast. She hit my car. Obviously, her car was damaged.
No, I was not. I'm pretty sure if I was, her door would be off.
She was going so fast, she was in a hurry. Of course, she wasn't paying attention, and she hit my parked car.
She came out of the car, she swung her door open, I hit it, and she said she was sorry because she knew it was her fault.
My door didn't come off. She hit the corner of it, so she just impacted her car.
Fortunately, she didn't have insurance, so it's illegal to drive without insurance, so I won the case.
It's simple that she hit my car, and I can't believe she's fighting it.
Have insurance.
I was doing the best I could to make it.
What are you, crazy, sir?
The landlord who never left.
You slept in the laundry room next door to his apartment. That's ridiculous.
And the tenant who wouldn't live with it.
I spent one night there, Your Honor.
How much did you give to Mr. Taxon?
$3,928.
And you gave him zippity-doo-dah. You're a scammer and a fraudster.
This is Judge Judy. Jacob Burke is suing his former short-term landlord, Joshua Taxon, for defrauding him out of rent and his security deposit.
Judge's case number 156, sworn in.
Thank you, Bird. Mr. Burke, I'm going to create very simply what your complaint is, and then I'll go into depth in a moment. You found an ad on Craigslist because you were moving from the San Francisco area to an area also in California called East Bay.
Correct, Your Honor.
The defendant has a home in East Bay. You advertised that you were renting out half that home. The home is divided into two parts, an upper level and a lower level. And you answered the ad for the lower level?
Correct.
And that included how many rooms, sir?
1 bedroom and 1 large living space.
And the rent on that was how much?
It was $1,800 a month. I also paid a $700 deposit, and we prorated the first month at $1,428. So that was December prorated and January in full.
Okay. So in total, how much did you give to Mr. Taxon?
$3,928.
And I assume that most of the communications that you had with Mr. Taxon were either over the phone or on the internet.
Yeah, almost.
That you never saw the rooms. You saw
we communicated almost entirely by text message and email, so we have a good record. And I did see the place about 1 month before my move-in date.
Personally?
Yes.
You went to see the space. And you were satisfied with the space?
Yes, Your Honor. At the time, it was being lived in, and so it seemed...
Who?
I'm not sure, Your Honor. Maybe a previous tenant or maybe Mr. Taxon himself.
Who was living in the lower unit, Mr. Taxon?
I believe it was a previous tenant.
What do you mean you believe? Who was living in the lower unit?
I cannot verify that answer 100%.
What are you, crazy, sir? Yeah?
No, I'm not crazy. I had many tenants, and I was utilizing my home to survive and pay the bills. So I had people in and out. I was also Airbnb-ing rooms in the house, and it was a lot of activity. I also have a young daughter, and I was busy with her.
I'm actually somewhat sympathetic because you brought this action very late. You understand that?
Yes, Your Honor.
There is a substantial period of time that's transpired between the time that you rented this apartment and today.
That's right, Your Honor.
2 years.
However, I tried to pursue a lot of remedies with Mr. Taxon, and as he made abundantly clear to me, if I took him to court and won, he wouldn't pay me. I mean, he wouldn't have the money. No two sticks to rub together. So I wanted to give him time to perhaps have the ability to pay.
Do you have that memorialized?
Yes, Your Honor. I issued him...
I'll get to you in a moment. Just a second. Okay, so this is the deal, Mr. Taxon. If this had been more current, there would be no issue, because I think that you're a scam artist. Because what happened is you were trying to keep ends together 5 days. You were sleeping in the laundry room right next door to his apartment because you had rented upstairs to Airbnbs, something that, of course, he didn't know because as far as it was presented to the plaintiff, there was a house with 2 apartments in it, upper and lower. He was renting the lower. Someone was going to rent the upper. He didn't plan on you living in the laundry room.
I was not living in the laundry room. I stayed in the laundry room.
Ridiculous. It's a fraud and it's a scam. And you took his $3,900, and then, according to you, you gave him on the 5th day a 30-day notice, and you didn't return his money. He stayed there 5 days. You had $4,000 of his money.
I spent one night there, Your Honor.
You're a scammer and a fraudster. And all he has to demonstrate to me in order to get this money is that between the time he moved out, which was sometime in January of 2019, that he asked you for the money and had communication with you hoping that he would get the money. Do you have that?
Yes, Your Honor. I have the demand letter that I issued on January 4th.
I'd like to see it.
And, Your Honor, I spent one night in that apartment, the night of December 11th.
Please note, just a second. Did he respond?
For quite a while. There was intense disagreement as to the reality of this.
How? Was it by text or phone?
Both text and email, Your Honor.
I would like to see what he said to you.
Okay, Your Honor.
Because now we have a demand letter. I would like to see what he said to you, just so that I feel comfortable that you tried your best, and the reason for the delay, this delay in a year.
Yes, Your Honor. Absolutely.
More.
So to set the stage
is because he's a deadbeat.
Yes, Your Honor. So to set the stage for I spent
deadbeat. That would be you.
I spent only the first night in that apartment, Your Honor. The next day,
I understand that.
Okay.
You told me that. You told me that. I heard it the first time. Just show me the text from him.
Okay.
He's texted me for 20 days, I'd like to add, Your Honor, and that's...
Who cares?
Your Honor.
I don't have
You're
time
a
for that.
fraudster.
He's a high-maintenance tenant.
You're a fraud.
I am not a fraudster.
You are a fraudster and a thief. You took his $4,000 and you presented him with something that was less than what he bargained for, and you knew it.
He was never happy.
You knew it.
If you read...
You knew it. You slept in the laundry room next door to his apartment. That's ridiculous.
You haven't seen the house.
That's ridiculous because you were renting the upstairs.
I was doing the
please.
best I could to make it. All right? I'm not a fraudster. The laundry room is large enough.
Just a second.
Okay, go ahead.
Just is good enough for your mother, maybe your brother, maybe your daughter. It's not good enough for a stranger who's working. You had a job, right?
Yes, Your Honor.
Do you have a job?
Yes, I do now.
Doing what? Then?
At the time, then I did not have...
Did you have a job then?
No, I did not.
Okay. He's not your mother, your brother. He's not a charity. He signed on for an apartment, a private place where he could live, and it turned out that you weren't selling him what he bought. And it was you looking at me sympathetically. I did the best I can. I have a daughter. I had an Airbnb. I wasn't working. But that's all very sympathetic, sir. But he's a stranger to you.
Right.
You took his $4,000 and you spent it.
I gave him...
You took his $4,000 and you spent it. And you gave him zippity-doo-dah. He slept there for a night. You gave him nothing. That's fraud and theft.
I also sacrificed quite a bit of income for him because he wanted to move in. He moved in early. It was December. It was the best time of year of this house.
No, he gave you money for it, $1,400. That was your bargain. He was supposed to get an apartment.
And he did. And he
didn't get it. He didn't get it early. These may be some of the tricks you play in your mind, and maybe your daughter believes that. I don't believe it. And if you sat down and had an intelligent conversation with yourself where you stopped playing a victim, maybe you would recognize that what you're saying to me sounds ridiculous.
Your Honor.
You sacrificed for him. Don't say anything. You sacrificed for him, a stranger, money that you could have made renting his place for $300 a night for an Airbnb. You think that I believe that you sacrificed for him? You charged him $1,400. The rent on the apartment was $1,800. That's to sleep next to the owner who's sleeping in the laundry room? Give me a break. Shut power off because I owe them. Oh,
Your
hi,
Honor,
Jake. So cleaning is going fine, but I'm reading. There's an issue with power. And I swallow my pride and ask you for help. Please don't feel pressured. They shut off the power in your house. And in addition to the $4,000 he gave you because he was moving in, you're asking this stranger, not your mother, not your father, not your brother, not your daughter. You're asking a stranger who's already given you $4,000 for another $500. Otherwise, when he moves into the house, there's not going to be any power. After this, after January, after the demand letter, that's all I want to see. Don't show me December 14th. I want to see after January. Do you understand what I said to you? That says Friday, December 14th. I don't care about it. What I want to see are now efforts to collect this money after you sent him the demand letter. Do you understand?
Yes, Your Honor. Okay, so our text messages end at the end of December, so we must have switched to...
I want him...
Yep.
I want his response to you, any of his responses to you. That I would like to see, any of his responses to you after January, after you sent him the demand letter.
Okay, Your Honor. There you see January 2nd.
Hi, Josh. Please let me know you...
His response is here acknowledging that he does have some time.
I'm not sure what you want to take care of. I have 21 days from the day you move out to return your money with an itemized list of any deductions. The longer you hold the space hostage, the longer it will take to resolve this. What does that mean, Mr. Taxon?
It means that he moved all of his things into the space and then he didn't occupy it. It means that you can't. It's hard to find the actual conversation because for 20 days he was texting me to get things ready for him, and he was wanting to move in early.
No, not sure. No, not early.
Judge Judy continues
In the itemized list, did you ever send it?
I did not send the list, and for that I am at fault. But he was.
You're at fault. You're a thief.
And later today.
Could you explain to me why it took you a month to notify him that you only got 65 shirts?
I took trust, which was my mistake.
That was a very big mistake.
Jacob Burke says former short-term landlord Joshua Taxon misrepresented his living situation. He is suing for the return of rent and his security deposit.
Okay, this says I have 21 days from the day you move out to return your money. That's what you said to him.
Correct.
With an itemized list of any deductions. That's what you say to him. I have 21 days from the day you move out to return your money. This is after he moved out.
Yes.
So what happened to the 21 days in the itemized list? Did you ever send it?
No, he threatened me to take me to court. I did not send the list, and for that I am at fault. But he was.
You're at fault. You're a thief. Judgment for the plaintiff in the amount of $3,928. We're done.
Your Honor, may I say one more thing?
What?
Well,
Thank you. Goodbye.
Thank you, Your Honor.
This case is concluded. Parties are excused.
I went to far more trouble for him as a tenant than I've ever gone for any tenant.
He has done this to many other people.
I no longer own the home. I lost the home.
That place was clearly in need of a deep cleaning.
Definitely would like to put it behind me.
I have found a much better place to live.
All parties in the matter of Campos versus Enriquez. Step to the podium, please.
Jose Campos is suing Francisco Enriquez for failing to deliver an order of T-shirts he paid him to print.
Mr. Campos, did you meet the defendant online?
Yes, I did.
And you were in the market to have some shirts made with a particular logo.
Yes.
You met him online and placed an order with him for how many shirts?
125.
With your logo on it?
Yes.
And on what date did you place that order with the defendant?
I believe August 13th.
Of this year?
Yes.
How much did you pay him?
1,003 was 75 cents.
And was that for the completed shirts with the logo or just for the shirts without the logo?
No, that's with the completed logo and the shirts included.
For 125?
Yeah. Yes, I mean.
And according to your complaint, what he sent you was half the shirts instead of
60 shirts, or no, 65 shirts, but they weren't completed. It was just blank shirts. They weren't even completed with the design.
And the defendant doesn't deny that there was no design on the shirts. Is that correct, Mr. Enriquez?
Correct.
And you do not make the shirts yourself. You buy them from a vendor. What is the name of the vendor from whom you buy the shirts?
It's Jiffy Shirts.
How long have you done business with Jiffy Shirts?
I would say about 5 years now.
I would like to see the invoice for the 125 shirts that was ordered and delivered to you from Jiffy Shirts. Why did you order 131 shirts?
Why? Because if I have an issue with the whole process of making the T-shirt, I can replace the one that I had damaged. So I always keep spare ones just in case.
Okay. I would like to see the invoice when you received it and paid for it to Jiffy.
Yeah, this is actually the invoice that I received.
No, that's the order. It doesn't have an amount there, sir, so you can't get an invoice if it doesn't have an amount of money.
Oh, you're talking about the amount of money? Yes, I actually have a screenshot on my phone if you want to look at it.
My question is, when you got the box of T-shirts, what did you do?
Just so I could wait until I received the design from Campos.
Okay. You didn't open them to look at them?
Yes, I actually did open it just to make sure that it was the brand.
Okay. When you open it,
yes,
inside there's a packing slip.
Mm-hmm.
Do you have that?
This is the packing slip that I got.
Do you have that?
Yes, this is the packing
I'd like
slip.
to see it.
You are seeing it. That's what I received.
No, okay. Give me a second. Okay, now I'd like to see the invoice.
Give me 1 second.
Mm-hmm.
There you go.
Mr. Enriquez,
Yes.
I'm looking up Jiffy Shirts. You say you got a bill from them
Yes.
for $830. Now, I just looked up Jiffy Shirts, and what you had with T-shirts, sir?
Yes.
And the T-shirts are $1.49 a piece.
$1.49. Are you really sure you're looking at the correct brand? Championship, not Gildan?
I'm looking at Jiffy Shirts wholesale T-shirts.
Correct.
$1.49, free shipping, always in stock. $1.49, save 50%. Bulk.
Judge Judy continues in a moment.
When you have lost faith in a business associate, as you lost faith in him, the first thing I would have done is open up the box and looked at them.
Real cases, real people. Judge Judy. Jose Campos says Francisco Enriquez never delivered an order of 125 T-shirts he paid him to print.
Okay.
If you actually look up Championship, the brand, it's a little bit more expensive. It's high quality.
So, Champion,
Yes.
how much do they charge you extra for the championship so that I don't have to look here? How much do they charge
The
you
championships
additional
are the
for
championships are actually $6 to $7 a piece, depending on the size.
I would like to see the invoice for that, sir, not the total. I would like to see your invoice in it, not the total $830.
Okay.
Did you tell him that you wanted the championship,
Yes.
Mr.
Yeah,
Campos?
it was very specific. Yeah, it was very specific.
Okay.
He did mention that the shirts were $7 flat.
Okay, you're giving me the same thing.
Yes, because this is the invoice that I received.
You're giving me the same thing.
Yes,
How
ma'am.
many shirts did you get, sir?
I got 65 shirts.
And you got 65 shirts that were worth $7 a piece.
Yeah, plus a
Right?
dollar for the designing. So he charged me $1 extra for the shirts.
Just a second, you didn't get a logo on them,
No.
correct?
Yes.
So what you got, according to you, was $455 worth of shirts,
Yes.
and you paid him $1,000.
Yep.
Okay. When, for the first time, did you tell him that you only got 65 shirts?
I told him November 6th.
And when did you receive them?
I believe I got him October 2nd.
Well, could you explain to me why it took you a month to notify him that you only got 65 shirts?
Since he did not complete the order by giving me the logo on the shirts, I had to take that time to find a different printer to be able to print the shirts for me. So therefore, I didn't even bother to look into the box because I took trust, which was my mistake. Trust in his judgment.
That was a very big mistake.
Yeah.
Judge Judy continues in a moment. Closed captioning sponsored by. Are you the victim of a scam? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Okay, that was a very big mistake.
Yeah.
Yes.
So,
don't make it any worse for yourself. When you have lost faith in a business associate, as you lost faith in him, according to you, that he wasn't delivering what you had ordered, and you said, I'm going to either come and get or send me the shirts, the first thing I would have done is open up the box and looked at them and notified him immediately that your order was shorted. Do you understand?
Yes.
Good. Good. Your case is dismissed. We're finished. Thank you.
Thank you. This case is concluded. Parties are excused.
And on the next Judge Judy.
Your towing company towed his car.
Correct.
Did he say that he didn't have your car?
They absolutely said they did not have my vehicle. They sold my vehicle.
Next Judge Judy.
He failed to accomplish an order that I placed.
It's not my mistake. It was his.
It was bad judgment. I trusted that he'd give me what I've ordered.
He demanded his shirts, and so I gave him his shirts.
This whole process that I went through is definitely a lesson.
My opinion is to never help anybody out.
For about 7 hours. When you came out to get it, the car was gone.
A driver in a frantic search.
Your towing company towed his car.
Correct. The security company that patrols that property had called us to remove that vehicle.
Then, did the tow company pull a fast one?
Did he say that he didn't have your car?
They absolutely said they did not have my vehicle. They sold my vehicle.
This is Judge Judy. Reginald King is suing tow company manager Mark Mathis for the value of his car and property after his vehicle was illegally towed.
Judge, this is case number 153 on the calendar in the matter of King versus Mathis. Parties have been sworn in. Have a seat, sir.
Thanks, Bert. Mr. King,
Yes, Your Honor.
you parked your car on December 17th of 2020, and when you came out to get it, either that day or the next day, the car was gone. Where had you parked it?
I parked it in the front of my residence, in front of a commercial parking space that's utilized for commercial businesses.
Show me a picture of where you parked it.
And my vehicle was parked exactly where this Honda Accord would be parked at.
Show me exactly, make a mark where your car was.
Park is where my vehicle was parked at.
And where do you live?
I live inside the gated community here where townhouses are. Inside of our gated community, there's restricted parking. And this area here...
Okay, just a second, Mr. King. What time did you park your car there?
My car had been parked there since that morning.
When did you come out and see that it was no longer parked there?
I took my daughter to the airport around 11. I went and took my vehicle and retrieved some keys. And then I took her to the airport. Once I came back that evening, probably around 6 o'clock, I noticed my vehicle wasn't there because it just had gotten dark.
So you had parked there for about 7 hours?
Correct.
Where had you gone in the morning before 11 o'clock?
Right around that time, I pulled my car, my son's vehicle, actually. I pulled it into that parking space. So I normally park it on the street.
Why?
I had my taco cart, and I had other personal belongings that I wanted to make sure it was secure, or someone would be able to see it if someone would try to steal it or break into it. So I didn't take my taco cart out of the vehicle because I was hosting my daughters that weekend, and we had a taco party that weekend.
Are you allowed to park there?
Yes.
Does it say parking for people who are using the retail businesses only?
It's for both our residents and for retail businesses that are there in front. It's a barbershop there. It's also an insurance.
No sign there. I only see a blue sign over in the corner that looks like a handicap sign.
Yes, ma'am.
But other than that, there are no signs that say parking here for shoppers in...
It's unrestricted parking, Your Honor.
And were you blocking anybody in?
No, my vehicle was bagged in to the rear gate was facing the barbershop. Because I had
what do you mean a rear gate where it was facing a barbershop? I don't understand.
I bagged in my truck where the front of the truck was facing the street, and then the rear gate was bagged in. I actually bagged the vehicle in.
But right in front of that store?
Correct.
Where it looks like a Honda is parked now?
That would be correct.
Okay. And you, sir, own a towing company, or do you work for...
I work for the towing company.
And according to your answer, because what happened here is your towing company towed his car.
Correct.
And is your claim that you towed it as a result of getting a call and his car was illegally parked, which you'll tell me about
That is
in a
correct.
moment.
His vehicle, it was unauthorized to be on that property. The security company that patrols that property had called us to remove that vehicle.
Let me see the message. Do you have the message?
Here's the impound slip with the security company and their signature authorizing the removal.
Did you physically remove the car?
No, the driver, Hector, did.
Okay. I'd like to ask him a question. Hector, what is your last name, sir?
Echeverria.
Mr. Echeverria, do you remember back to December 17th, 2019, when you towed the plaintiff's car?
I do remember, yes.
You do?
Yes.
I want you to be clear. Don't say you remember if you don't.
No,
you do remember
I remember
that.
being there that day, yes.
When you got there, approximately what time did you arrive at the location where the plaintiff's car was parked?
I must have got there about 6:40, 6:45, around that time.
In the evening?
Yes.
Did you see any reason that his car would have been towed?
Well, I mean, when I got there with security, usually from my understanding...
No, don't, look at me. Look at me, Mr. Echeverria.
Okay.
Don't tell me usually, don't tell me basically, don't tell me what somebody else told you. Did you see any reason when you looked at the car and looked where it was parked for the car to be towed?
Yes, because he wasn't a customer for the stores.
So what you're saying was the people who were parking there were supposed to be shopping in those stores.
From my understanding, yes.
But there was no sign that you saw that said that.
There was a sign at the entrance of the property.
That says what?
Private property.
Where's a picture of that?
I don't have a picture.
So the answer is, other than the fact that monitors that space, there was no other, I mean, he wasn't blocking another car. He was parked there. And if he had been a customer in one of those stores, which were either open or closed at the time, there would not have been any reason to move his car.
Well, I'm not sure what the rules are there for that property.
You're not sure?
Well, I mean,
you were just given a job to do.
Right.
You were just given a job to do to
Yes.
tow that car.
Yes.
And it was easy to tow. It wasn't blocking anybody else. It wasn't parked in 3 spots. It was just parked in one space,
Right.
backed into one space.
Right.
Okay. Now you can sit down, Mr.
Thank you.
Echeverria. Thank you. Okay. Now, Mr. King, so your car was not there when you came back on the 17th. I'd like to see the police report that you have from the 17th reporting a stolen car.
And, Your Honor, I do not have that police report. I had a whole entire file, and I was remiss in not bringing the actual file when I originally sued Mr. C's. I went to the police station in Lakewood. I contacted first Mr. C's Towing at 9:55 p.m.
Just a second. That evening, you contacted the towing company.
That would be very correct.
Oh, interesting. So that evening, you contacted the towing company, and you contacted the towing company. You knew to contact the towing company, Mr. King, because they're customers only. Unauthorized vehicles will be towed by Mr. C's towing company.
No, the sign is...
Let's just process what I said.
Yes, ma'am.
If I were missing my car, I wouldn't know to contact Mr. C's towing company. The first thing I would say is, somebody stole my car. So now you can tell me what prompted you to call Mr. C's towing company.
As you enter our residence, and as it describes, our residence is private property. It's a gated community. Inside, there's restrictions for parking for exclusively residents only. So my first indication, since the car was missing, was I asked the gentleman that owns the barbershop, did you see something happen today with my car? He doesn't recall.
Don't tell me what anybody else told you, sir.
Absolutely. I looked at the gate. I retrieved Mr. C's telephone number.
Just a second. That's exactly what I said. You saw his name on a sign that had a restricted parking signature on it. And my sense is, Mr. King, that you knew you weren't supposed to park there.
Not correct, Your Honor.
My sense is my sense is you knew you weren't.
I think I may not have done a good job explaining it, Your Honor.
You maybe not, but on the same day that your car was towed, you called him. And did he say that he didn't have your car?
They absolutely said.
You spoke to?
Their dispatch.
Okay, I'd like to see proof of that.
Right here, Your Honor. You see that on December 17th, my telephone records, my name, 9:55, I made a call to Mr. C's at 323, and they can validate that's their accurate number.
Well, it was an accurate number, and you were on the phone for 1 minute with them.
Correct.
And if I were to call that number, I would get dispatch.
That would be correct.
And in 1 minute, you said, did you tow my car, a Chevy Blazer, and whatever? And dispatch said no.
Yeah, I gave them the address. I gave them a description of the vehicle, and they informed me that they had no tows from that address.
And you called them at what time?
At 9:55 p.m., Your Honor.
Okay. So then you filed a report of a stolen car.
Correct.
Did you ever call Mr. C's back again?
Not until they contacted me in March demanding payment for storage after they sold my vehicle in a vehicle lien sale.
Okay. Now, I'm coming back to you, Mr. Mathis. Mr. Mathis, I'd like to see your paperwork on the notices that you sent to Mr. King.
Yes, ma'am.
Okay.
Now-
First notice. Let's go with notice number 1.
Here is the notice that after to process our lien sales. Here's the notice that is sent to all the registered and legal owners.
No.
Okay,
no.
what are you looking for?
No. That's not what I asked you.
What did you ask me?
Don't tell me that's somebody else. That's somebody else's document. That's not your company's document.
Oh,
Is
no.
that right?
That is correct.
I want to see Mr. C's first notice to the plaintiff that you towed his car.
We hire an outside company to process all of that paperwork.
Okay, very good. Then you're going to pay him for his car.
I don't
because
believe
you
so.
don't have the evidence.
No, I do.
Oh, yes, you are. Oh, yes, you are. Show me. Show me. The
Sure.
fact that you give it to an outside company that you don't have here, you can't show me paperwork from an outside company.
Why
you
not?
can show me paperwork from your company. Why not? Because it's hearsay. Because it's
this
hearsay.
is a
If
legal
you're
document.
introduced, no, it's not a legal document,
It's
sir.
not a legal
document. It was
document?
filed by some. No, listen to me. You have to have the person here so that I can grill them exactly like I'm grilling you.
Would you like their number?
As to, do I want their number?
Yeah, he's in San Diego.
Like you brought Hector, not yeah.
Yeah.
Just like you brought Hector.
Yeah, that
Mr.
was probably a
Mathis,
mistake,
you
huh?
bring.
Your Honor.
Oh, you're such an idiot.
Judge Judy continues in a moment. And later,
with no drivers in it.
Now show me the damage. So he went in there.
Yes. So this picture is showing almost hit the neighbor's garage wall.
Reginald King says Mark Mathis's tow company illegally towed his car and then sold it.
Anyway, listen to me. The value of your car clean is $2,000. I just looked it up. That's the average clean price for a 2004 Chevy Blazer. So $5,000 is not in the ballpark, sir. You say that there were things that were in the car. One of the things that you say was in the car was a taco cart.
Correct.
And the taco cart you say you had in the car because you had had a party for your daughter. I'd like to see a photograph of that cart, and I'm not entertaining anything about your son's golf clubs. What is that?
That is a taco cart. It is big enough for me to cook 50 pounds of meat.
I don't think that's going to fit inside of a Trailblazer.
I'm not asking you a question. There's not a question
Yes,
before
ma'am.
you. That's a piece of metal. That doesn't look like it collapses.
It absolutely does comes off. The top portion
Very
here
good.
is very
Very
heavy.
good. I'm not giving you any money for a taco cart, sir. I'm not giving you money for a taco cart. The Chevy Blazer, the average clean price for a Chevy Blazer is $2,000. Judgment for the plaintiff. We're done. Thank you.
Thank you, Your Honor.
This case is concluded. Parties are excused.
This definitely was an illegal tow.
I think everything was done legally.
I've had incidents with Mr. C's.
And he shouldn't receive any payment.
On a few occasions of them being aggressive.
100% legal.
Coming in, attempting to tow vehicles without security.
Business as usual.
It was legally parked and illegally towed.
All parties in the matter of Kacharian versus Hubbard, step to the podium, please.
Neshan Nick Kacharian is suing his neighbor, Steve Hubbard, for damage to his property after Steve's truck rolled down a hill and into his front yard.
Mr. Hubbard, I'm going to start with you because there really is no issue in this case as to fault and responsibility. The only issue in this case is damages. Because from what I understand from both of you, you both own your own property in California, and your property is slightly elevated from the plaintiff's property. And on September 22nd of this year, you were doing something with an old truck that belongs to you, and either you were towing it or, according to you, the road and stopped in the plaintiff's yard. The plaintiff says that your truck caused damage to his landscaping of his yard. You subsequently had to have the truck towed out of his yard, which the tow truck caused further damage to a landscaped home that he said was extensive. So you explain to me, Mr. Hubbard, why, if he can prove to me that the insurance company paid him for the damage, but he had a $1,000 deductible so that he could redo the lawn and redo the planting beds, why you're not responsible for that.
Judge Judy continues in a moment.
Did you have insurance on this car?
No,
Did they
I didn't. I didn't have it. There was no reason to. Nothing happened.
What do you mean nothing happened?
Nothing happened to his bush. Nothing happened to the tree. Nothing happened to anything.
Oh, you're just a fool. Didn't you see the photographs?
Real cases, real people. Judge Judy. Neshan Nick Kacharian says his front yard was damaged when a truck owned by neighbor Steve Hubbard rolled down a hill and onto his property.
So you explain to me, Mr. Hubbard, why, if he can prove to me for the damage, but he had a $1,000 deductible so that he could redo the lawn and redo the planting beds, why you're not responsible for that.
The damage that was done to his car, that was done to the car, was nothing at all.
It was nothing. So you're saying to me that he committed insurance fraud.
Correct.
Okay. So now, sir, you show me photographs of the damage to your property. I'm sure you took a series of photographs when his truck was on your property.
Correct.
I'm sure you did.
Correct.
Right. I'd like to see them.
Should I show you all the pictures?
Just show me the... Yeah.
Or just the
Well,
damage?
start with the best ones.
This truck is going down the hill with no drivers in it.
Good. That's the truck. Okay. Now show me the damage. So he went in there. Right. Now, did he go in between the... Oh, I see he
Neighbor
took
side.
down trees.
This is from the neighbor's side.
Okay, so that's going through your yard and going through those
Neighbor's wall.
boxwood trees.
Correct.
But are the boxwood trees yours?
Yes.
No.
So this picture is showing almost hit the neighbor's garage wall. It's only 3 feet away because of the weight of the truck.
That's the neighbor's garage.
Correct.
Okay, next picture.
Okay. It's open, huge, wide
Hey,
open.
no, what I'm telling you is you can see clearly that he went through the bushes on your house.
Right.
Got it. Next.
That's it.
That's it. And do you have the letter from the insurance company indicating to you how much they're paying you?
Correct. I do.
I'd like to see it. Now let me see the bill from your landscaper.
I did not apply for the landscaping until finalized in a second.
It's an estimate. It's not a bill.
Right. Hold on.
Show me. Just show me.
I will.
Okay. Demo damaged area. Repair brickwork. Replace 10 to 15 Potsodium dwarf. Where is a 24-inch box pygmy palm? Is that the dead palm?
No.
Well, show me which one he killed. I see the bushes. That's clear.
On this,
I just want to see the picture of it.
right. On this image, it was a small one, okay, that was damaged underneath these bushes, but it's not talking the big one. The big one, I understand, because of the wind that is, so killed. But I'm talking the small one. It's not showing the exactly by zooming the small plant. Now, the only thing I'm claiming, high bushes, $880. Insurance company covered only $500.
That's too bad.
Judge Judy continues in a moment. Closed captioning sponsored by. Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay. Now, Mr. Hubbard, do you have homeowners insurance?
Yes, I do.
Or did you have insurance on this car?
No,
Did they
I didn't. I didn't have it. There was no reason to. Nothing happened.
What do you mean nothing happened?
Nothing happened to his bush. Nothing happened to the tree. Nothing happened to anything.
Oh, you're just a fool. Didn't you see the photographs? Judgment for the plaintiff in the amount of $1,000. We're finished. Goodbye.
Your Honor.
Goodbye.
Your Honor, may I ask you a
Goodbye.
question?
We're done. No, nothing. We're done.
This case is concluded. Parties are excused.
And on the next Judge Judy.
What do you think that I think that you did to her car?
I was going over there to get my payment. I had no motivation to scratch your car.
Pay careful attention, sir. You're not as smart.
Judge Judy.
I noticed Mr. Hubbard coming down the hill and explain what he tried to do, tried to pull the truck with another car.
The brake went out and it took off down the street.
Snap and rolling down the hill with no driver in it.
I walked after it. I didn't have to run. I walked. It was barely moving.
Is luckily, so no one got hit or had a collision with another vehicle.
Yes, I was very lucky.
He accepts 100%, responsibility.
I'm lucky it didn't go through the neighbor's front garage.
No more truck in the house.
Nothing. Nobody got hurt. Nobody got killed. Nothing happened to anybody.
You told him to leave the job. I assume that that's what happened?
Yes.
Did a frustrated handyman
I was going over there to get my payment.
do a job on her car?
Is that you, sir?
Yes, Your Honor.
What do you think that I think that you did to her car?
I had no motivation to scratch your car. I wasn't angry. I had no problem.
Pay careful attention, sir. you're not as smart.
This is Judge Judy. Kimberly Page is suing her neighbor, Daniel Bazugaloff, for damage to her sliding door, damage to her car, and punitive damages for vandalism.
Judges case number 159 on the calendar in the matter of Page versus Bazugaloff.
Miss Page, from what I read, you met the defendant, Mr. Bazugaloff, at a neighbor's home. Shortly after you met him, Mr. Bazugaloff moved into this neighbor's home. Were you a tenant in this neighbor's home, sir?
Yes, Your Honor.
Okay. Are you still there?
Yes, Your Honor.
And during the course of discussions, you indicated that when your house was built, the sliding doors in your house were put in backwards, yes, which was an issue for you. Yes. And your friend and neighbor said, gee, my friend, a new tenant, Mr. Bazugaloff, fixed my sliding glass doors. Maybe he can fix yours.
Correct.
And he came over and took a look at it. And he said, I can, in fact, fix it. And you agreed on a price, and you agreed for him to provide the materials, to go out and buy the materials, and to reimburse him for the materials he needed. So far, am I correct?
Not exactly. We never actually agreed on a price. I did agree to pay him for the work that he was going to do.
Okay. If you say, I will pay you for your labor, that presupposes that he is going to fix the amount he charges for labor. You do understand that?
Yes, I do.
Okay. When did he start work on your doors?
He came over on the 27th of October, and the following day he came over, and when I was at work, and he started working on the door.
On the 28th of October?
Yes.
Do you have photographs of the door?
I do.
I'd like to see them.
This is the work that was done.
Now, let me see the whole... Do you have a picture of the whole door?
Actually, in the photos, I have a picture that was taken from a far distance away, so it's not really a clear picture of the door.
Well, I would like to see a picture of the door now, and if you had one of the door then. Do you have pictures of the door now?
Oh, this is basically the picture that I have of the door. That's as good as I can probably provide you at this time, because that's the door before he worked on it.
And this looks like it was in a room that was being renovated.
Yes,
what was being renovated in that room?
The kitchen.
Okay. And in what month and year was that picture taken?
This was taken just right before he had worked on the door in October.
So the sliding glass doors from the kitchen, and I assume that that's into either a family room or a dining room, were put in backwards. You want him to put it in right, and it is your claim that he didn't do a good job, that he put them in upside down.
No,
okay.
actually.
So now, not upside down? How did he put them in wrong?
Because he said that the door wasn't lining up with the frame the way he had put it in, but what he needed to do was turn it around, and it lined up perfectly when I did it. But he had already cut the frame when I was at work with a cutting tool and made...
Then I have to see what the door looks like now. Did you put the door back in, sir?
The door had to come out, yes, Your Honor. The door had to come out due to the fact that her running frame was so old and so damaged that the frame itself had to be replaced. Not the doors, but the framing. And that's why I was grinding to remove the frame.
I have to see. Well, I don't know if it's ridiculous or not. Do you have somebody who fixed the door after he did what he did?
Yes, I do.
Okay. I'd like to hear the person who you have that fixed the door. Who is that?
My husband.
I'm not interested in your husband.
I actually haven't replaced the door yet.
I'm not interested in your husband.
I haven't replaced the door
So
yet.
you mean there's no door in your house? Is that what you're telling me?
The door is, when he put it in incorrectly, which made it not line up properly to the frame. So he cut the frame.
I don't know that because you don't have photographs for me to look at. That's what you're saying to me. He says to me that the frame was old and didn't match the door, so he had to grind it down and put...
Yes, Your Honor, I had to grind it to remove it to put in the new frame. If you look at the frame itself right now, you can see the house was made in probably the early 70s. You can look at the frame and see that it's weathered and it's worn out.
Okay, my house was built in 1989.
Well, so it's only 30 years old. But if you had had it fixed, madam, and you had a bill for having it fixed because what he did was wrong, and I have the person here who can explain that to me, that's fine. Showing me photographs of little bits and saying my husband fixed it.
Okay, no, my husband
and I've been living with a fixed door.
No, my door hasn't been fixed. My door looks horrible. It still looks like this. You can't lock it. The frame, if you rubbed up against the side of it, you would cut your arm or you would rip your clothes. It's not fixed. It's horrible.
Very good. Okay, let's forget the door because you don't have enough evidence for the door, Miss Page. The second part of your lawsuit is you say that when he came to collect his money, materials that he bought, and for the labor that he put in, he came several times and there was no cooperation. It is your claim that in retaliation he vandalized your car.
Oh, yes, absolutely.
And you said that you have evidence to prove that he vandalized your car. On what date do you claim he vandalized?
Camera. It was on November 17th at exactly 7:57 p.m., which I have a video that I've submitted.
Now, did you have any contact with him on November 17th?
Yes, he came to my door directly after he keyed my car. He came to my front door.
So you eventually told him to leave the job. You didn't want him to finish this job. I assume that that's what happened?
Yes, that was the next day after this. He didn't do anything more after.
So that was the 28th at the 28th or the 29th?
Correct.
Okay. And he came to your door on the 17th. What exactly did he say to you?
He said, if I would have let him finish the job, it would have been painted and everything would have been great. But, of course, I did not let him do that because I was very unhappy with the fact that he cut the frame without my knowledge when I was at work, and I had no idea he had done that. I would never have let him cut the frame.
Well, that calls for him to know the operation of your mind. You told him to fix the door.
All he was supposed to do was turn it over and to put it on the other track.
Good. That's wonderful. I don't even have to go into that. He came to your door and said to you what?
That if I would have let him finish his project, I would have been happy with it. It would have been fine. Said to him that I would pay him $20 for the rollers that he had purchased, but that was all I was going to pay for.
And what did he say?
I said, and actually also what I said was that after he left, I turned the door the correct way and everything lined up perfectly. There was no need to actually cut the frame, is basically what I told him.
So he came to the house looking for payment for the equipment that he bought and for the work that he did. And you said all you had to do was turn around. I'll pay you $20 for the rollers because you did, in fact, use the rollers.
Yes.
Right?
Yes.
So he came to the door and he asked for the money. You told him, I'll pay you for the rollers. That's all I'm paying you for. And you say it's before he actually came to the door that he keyed your car, not afterwards.
Yes, I'm assuming that he had
Don't assume. Don't assume. Okay. Just a second. Do not assume anything. Just the facts as you saw them, heard them, smelled them, tasted them. He came to the door.
He came to the door.
But according to the surveillance that you're going to show me,
yes,
he keyed your car first.
Yes. That's correct.
And that was on November 17th at 7:57 p.m.
Correct.
Where you acknowledge that you went to the plaintiff's home to ask for your money on November 17th on or about between 7:30 and 8 o'clock.
Absolutely. I had no motivation to do anything bad because I thought I was going there to get my money.
Just a second. Just a second. You acknowledge that you went to the plaintiff's house between 7:30 and 8 o'clock on November 17th. Is
Yes, Your
question.
Honor.
The answer is yes. Okay. And were you aware that the plaintiff had surveillance cameras?
Yes, ma'am.
Now I'll see the footage. Is that you, sir?
Yes. Yes, Your Honor.
Yes, of course it's you. Now let's play that again. Start from the beginning. It's coming out of...
You can hear it so badly.
Yeah. Putting it away, coming in. Well, sir, what do you think that I think that you did to her car?
I did absolutely nothing to her car. If you look at me walking up to the door, my left hand is in my pocket.
Yeah.
No, sir, it is not. You put your... Don't let... If you think this is funny, I'll let you take it to a court where you think it's funny.
Judge Judy continues in a moment.
Because Kim avoided me, another week went by, and then you went to her door. Your excuse was, what reason would I have Just pay attention. You're not as smart.
Kimberly Page is accusing neighbor Daniel Bazugaloff of damaging her sliding door and vandalizing her car. Daniel is countersuing for materials and labor costs.
Okay, you walked out of your house. You live across the street, is that right?
That is correct, but I actually pulled my Suburban into her driveway that night.
Just a second. I didn't see that, sir. I saw you crossing the street. I heard a screeching sound. Listen to what I heard. I heard a screeching sound and you walking around, putting back into your pocket something, and then walking in the door. I want you to look at it carefully again, sir.
Yeah, I disagree completely. It's such a tight walk there between the bushes and the car.
Just watch it again.
I'm on the right side of the car, Your Honor, not the left side. I was never on the left side.
Which is where it's key side, and then he put his hand in his pocket.
Show me where my hand goes into the pocket. It's in the pocket the whole time.
No. It's not in the pocket the whole time.
Show me where.
No, it isn't.
I don't see where it isn't.
I'm going to show. Play it again. Play it again.
Pause it wherever that's the case.
Play it again. Play it again.
My hand's in my pocket, though.
Right there. No, you just put it in your pocket, sir.
Back it up, and I'll put it on pause, Your Honor. You can see my hand's in the pocket.
Put it. No.
I should be able to do that.
You just put it in your pocket.
That's not true.
Well, what I'm telling you is I saw you put it in your pocket. You want to watch it again?
Can someone freeze it when?
Let's go.
Freeze. Okay, where's my hand?
Yes.
Put it in your pocket.
You're putting it in your pocket. Now keep walking. And then you put it all the way in your pocket. Keep walking, keep walking, keep walking, keep walking. By the time you get past this pillar, it's all the way in your pocket. Now it's all the way in your pocket.
First of all, you can never even see my hand to see whether I scratched the car or not.
May I see the damage to the car, please?
Oh, it's horrible. It's just horrible.
While you do that, may I say something, Your Honor?
No, I'll get to you in a moment. Okay.
It's a very long scratch.
Yeah.
I don't remember.
$1,400 of damage.
Don't answer him.
Sorry.
When did you park the car? Did you park the car on the 17th or the 16th?
The 17th. I went to work that day, and I came home, and he came to my home.
When you came home, and there was no damage on your car?
No.
Is that?
Yes. Then the next morning.
When did you notice?
The next morning when I went to go to work. And I gave him the $20.
Did you?
I didn't know that he had keyed my car yet. Or obviously, I wouldn't have paid him anything. But I didn't know that there was any damage until the next morning.
Okay. May I see the estimate to fix the scratch?
Sure.
While she's getting that, may I say something, Your Honor?
No, not yet.
This is dated the 30th of November.
Have you had the car fixed?
No, I have not.
No. Okay, now, sir, now I'm listening.
Okay, first of all, her estimate, she said, was November 30th, and this happened on the 13th or 14th.
No.
She waited a month to...
17th.
If you answer him, I'm going to do you understand? You said sorry. That's the fourth time you said sorry.
Seems highly unusual.
Go ahead.
Seems highly unusual to me that if somebody scratched my car that bad, I knew who did it, what was going on, I would have got an estimate right away on it. I wouldn't have waited a month, almost a month, to get it.
Who cares?
Second of all, I had no motivation to scratch her car. I wasn't thinking I'm collecting money. So there was no reason. Now, if I would have scratched the door on the way out, that would have been different. Then I might have some motivation to do it.
Now, just a second. Is that what? Just a second. Is that your response to me? See, I said I would listen to your response and then hear it and try to fit it into the facts. Is that your response?
First,
you say, don't speak. Now listen. This is what you swore to in your answer. For the next 2 weeks, I went to their home several times to talk to Kim and work things out. Their cars were in the driveway, but no one answered the door. Because Kim avoided me, I left a request for payment in the mailbox. That included an itemized list of materials and missing tools. And then you say, another week went by, and then you went to her door. What you just said to me, your excuse was, what reason would I have? Just pay attention. You're not as smart.
Judge Judy continues in a moment.
By the way, did you make a police report?
I did file a police report, but I didn't have the video at the time. So they said they would press charges.
Don't tell me what somebody else said.
Real cases, real people. Judge Judy. Kimberly paid her sliding door while attempting to install it. She also claims Daniel vandalized her car.
Okay, you just gave me your answer because you wanted to interrupt her a moment ago. And you said, what in the world would I scratch her car for when I was just going over to ask her for payment?
We had previous conversation.
You had been asking her for...
We had previous conversation of that.
I'm speaking. You had been asking her for 3 weeks for payment, and according to your answer, which you swore to, she was avoiding you. And you put notes in her mailbox. And then you let another week go by in the evening, and you went over again. So I'm just answering your question. You asked to speak twice when she was speaking. I just responded to your first answer.
It's a commonality.
What's next? What's next?
Previously.
What's next?
The day previously.
Just what's next?
The day previously. The day previously, we had talked about the payment, and I went over to get the payment. That's what I did. I had no intentions of malice or anything. I thought I was getting paid, Your Honor.
Good. By the way, did you make a police report?
Yes.
I'd like to see it.
I did file a police report. The first time, it was just over the phone. They didn't come out. The second time, I did have them come out, but I didn't have the video at the time. So they said they would press charges.
Tell me what somebody else said. The answer is,
okay, yes.
According to you,
yes.
You called.
I called.
On what date did you call the police?
I called that same day that I saw the scratches, which is the 18th. And I have it on my calendar.
Okay. And on what... Just answer my questions, would you please? Okay. Taking far longer than it has to. Did you file a claim with your insurance company?
I did, and they had me get an estimate.
No, look up. Oh, and what's your deductible?
My deductible is $300.
Okay, so that they will, I assume, be sending you a check for the $1,400 estimate less your $300 deductible.
Correct. If I file, yes,
right.
They put a hold on the claim until I told them to, yes, go ahead and go through with it. Yes.
I don't, yeah, blah, 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 blah.
Judge Judy continues in a moment. Closed captioning sponsored by. Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Now, what you do in November is you file a claim with the insurance company, and if you have a $300 deductible, they should have come out and looked at your car and sent you a check. And then you sue him for the rest. He's absolutely responsible. You're not going to get paid.
I was waiting to go to court because I didn't want...
Well, you were going to court to sue him for the $300.
I didn't want to file a claim if I didn't have to, but I mean, yeah, basically. I mean, I don't know how all this works. This is all new to me.
Judgment for the plaintiff in the amount of $300. I assume you're going to submit this to your insurance company. We're done. Thank you very much. The case is over.
Your Honor,
We're done.
I do have a counterclaim.
It's dismissed. You vandalized her car. It's dismissed. We're done. You vandalized her car.
I did not.
Goodbye.
This case is concluded. Parties are excused.
And on the next Judge Judy, the problem.
Paint splatter on both of your cars. You acknowledge that you were spray painting the fence. Look at me. I'm not liking the smile.
Judge Judy.
The frame was so bad, it needed to be replaced.
The fact that I came home and my door frame was cut.
She had actually looked at the door that I did at my house, liked it, and said, well, could you do the door at my house?
I wish I never had him.
I didn't scratch the car.
I definitely know he did damage to the car.
When I went to the car wash, it wasn't coming off.
The proof.
You saw the defendant spray painting the fence.
He and two other people.
Now is the painter.
You acknowledge that you were spray painting the fence.
Personally, I wasn't.
Part of a cover-up.
What were you doing there? Look at me. I'm not liking the smile.
This is Judge Judy. Brian Fraley and his cousin Rachel Watkins are suing Roberto Munoz for damaging their cars while he was painting a fence.
Judge, this is case number 149 on the calendar, the matter of Fraley Watkins versus Munoz. Parties have been sworn in, Judge. Sir, have a seat.
Thank you. Mr. Fraley, this is your cousin. Miss Watkins is your cousin?
Yes. Yes.
Did you both have cars that were allegedly damaged by the defendant?
Yes.
Yes. Okay. What kind of car do you have, Mr. Fraley?
I have a 2018 Hyundai Sonata.
And Miss Watkins, what kind of car did you have?
2017 Honda CRV.
And both of your cars were parked in front of Mr. Fraley's house?
Correct.
Correct.
Do you also live there?
No, I do not.
But your car was there?
Yes, I was visiting.
In July?
Yes.
Okay. It is your allegation that in July of spray painting a fence, a job that they were contracted to do across the street, were not careful and got paint splatter on both of your cars.
Correct.
Correct.
That's your case.
Yes.
Mm-hmm.
Then there's some nonsense about lost wages because you're an Uber driver and you couldn't drive the car because it had paint splashes on it. I'm not interested in that. When did you first notice that there was damage to your car, Mr. Fraley?
I noticed
What
that
month?
it was September.
Okay, so this happened in July. So you're talking about 3 months later.
Actually, August. It was actually August when I first contacted Mr. Munoz.
Okay, so that's within a month
Correct.
of the incident.
Yes.
When did you first notice that there was damage to the car?
In August, it was a couple weeks after they had painted. I went to get my car washed, and we had fires at that time. We had fires all around California, all around us. And so I thought it was ash and soot, so I went to the car wash, and it wasn't coming off. So I asked the detailer what he thought it was, and he said it looks like...
Don't tell you, just don't tell me what the detailer said.
Okay.
That's hearsay.
Got it.
Now, Miss Watkins, when did you first notice there was damage to your car?
It was ash from all the fires, and when I went to the car wash, I noticed it wasn't coming off, and then I remembered that there was the painting of the fence, so
Okay.
I just...
Now I'd like to see the damage that you are alleging caused, because, Mr. Munoz, you acknowledge that you were spray painting the fence across the street in July.
Personally, I wasn't.
Your company was.
Yeah, I guess you can say that. But I actually know the customer actually paid the gentleman herself to redo it. Ryan.
What?
Yeah. I initially.
Well, then what are you doing there?
I have no idea. I guess I'm his only form of contact that he had regarding the paint, and he blamed me for it. I tried to explain to him I didn't do it, but he didn't.
Do the painting?
No,
Just a
there was two times we painted it. The first time I painted it with a roller and brush. The second time was with the sprayer, and that was when he got contracted to do the job.
Just a second. Who paid him to do the job?
The customer, the owner of the house.
Not you.
No. I tried to explain that to him.
We'll get to that in a second. Okay. Mr. Fraley.
Yes.
Mr. Munoz, who you're suing, says that he didn't do the spray painting on the fence. Somebody else did. He has that person here to say that he's the one who spray painted the fence, that he didn't pay him, and that you're suing the wrong person.
It's nonsense. I can see them outside my door,
You have a
outside
picture of
my
it?
window.
You have a picture of me?
And they were all out there.
Just a second. Don't speak.
Sorry.
So is what you're saying to me that you saw the defendant spray painting the fence? Is that
Correct.
what you're saying?
Yes, he and two other people.
Okay. Hold on. Mr. Munoz,
Yes, ma'am.
is it your statement that you personally, nor your company, had anything to do with spray painting this fence?
The second time the fence got painted, I assisted with helping him, sand down the previous paint. I did present myself before he started because I wanted to make sure that he went and knocked on every door to let them know that they were going to be painting, which he did. Also, he did.
No. What were you doing there?
Well, being that I built the fence from the ground up, it was still my baby. I wanted to make sure the customer was going to be happy regardless. I don't want nothing foul to go wrong. So I was here, make sure I oversee the job being done, even though I wasn't getting paid for it. But still, I
So
wanted it to
you
be
were
done
not.
right.
Just a second. Did you receive any compensation for spray painting the fence?
No.
Could you bring up your witness, please? Tell me your name.
Ryan Ramirez,
Mr. Ramirez, how much were you paid for spray painting the fence?
$1,300. Yes, I did.
Who helped you?
My buddy Chris.
And you have his phone number.
Yes.
Look at me.
Yes.
And were you paid the $1,300 by check or cash?
Cash.
From whom?
From Irma, I believe her name is.
Did you ever personally speak to Irma?
Yes.
On what date?
I couldn't recall the actual date.
Did you get the referral for the job from Mr. Munoz?
Yes.
Have you done spray painting before?
Yes.
For other people or for Mr. Munoz?
For other people.
Do you have a company?
No.
So it's word of mouth you get the jobs.
Yeah.
Do you have your own spray painting equipment?
No.
Where do you get the spray painting equipment from?
I got that from...
No. Look at me. I'm not liking the smile. Where did you get the spray painting equipment from?
From Roberto.
From Mr. Munoz?
Yes.
Did you pay him for the spray painting equipment?
No, I did not.
Sit. Now you can sit. Now he's got the right defendant. He's got you. He's got you. Eventually you get it. Now all I have to do is see the pictures of the damage that you allege occurred.
Can I see those pictures also? I have yet.
Absolutely.
Thank you.
Okay. Where is that a picture of? Is that a picture of the front of the car?
This is the front of the car.
Okay.
And I have more. That's the back
now,
of the car.
Those are two different... Of the same car?
Of the same car. This is the brake light.
That's the brake light.
This is the pictures of the windows.
Yeah, go ahead.
It's kind of a little hard to see because of the glare, but...
Okay.
There were 6 cars, wasn't there, Your Honor?
Can I see? Don't say anything.
Okay.
Please, don't say anything.
Sorry.
That's of the front window where the windshield wipers are.
Got it. Okay, next.
And this is a picture of the hood.
Okay, now can I see pictures of Miss Watkins' car?
Yes. That is my front light.
Got it.
This is my driver's side mirror.
Got it.
And these two are the hood of my car. There's a little glare on it, but those are the hood.
Got it. Now, I see. It's clearly paint splatter. Would you take all those pictures and give them to Mr. Munoz, please?
Yes.
Now, do you buffed out of that spray paint?
Yes, ma'am.
May I see it?
They gave it to us separately, so they're not together.
Yes. I want to see them, sir.
It's Photoshop.
Okay. So the total cost for one car is $900?
Correct. And it's the same person who did the same. He's doing another estimate for her. Same price.
Yes. Looks very, very reasonable.
Judge Judy continues in a moment. And later today.
So when the dog walked in, he
knocked into it, and then the pole started teetering over, making a scraping sound as it was going down, and then the ringing when it hit the floor. He ran underneath the jet ski trailer, and when he came out wagging his tail,
there was only a piece of it left.
Closed captioning is provided by Brian Fraley and his cousin Rachel Watkins claim Roberto Munoz damaged their cars with overspray while he was painting a fence.
Do you have estimates?
Yes.
May I see it?
They gave it to us separately, so they're not together.
Yes. I want to see them. Okay. So the total cost for one
person doing another estimate for her. Same price.
Yes. Looks very, very reasonable. Listen, you got to be more careful, Mr. Munoz, with the people that you hire and the equipment that you let them use. Judgment for the plaintiff for the amount of $1,800 that you split between two of you. We're done. Thank you very much.
Thank you.
This case is concluded. Parties are excused.
It was the right decision. We actually saw him do it.
I think it wasn't a good decision at all.
My grandfather and I both saw him, all of them do it.
It's just pretty much his word over mine. That paint could have came from anywhere.
That was absolutely false. I have evidence that the people that hired him, he got paint all over their cars as well.
He said it was 3 months ago, then he backtracked and he said it was only a week ago. I mean, come on.
What I saw them doing at first was sanding, and then
right off the bat, she believes it.
A couple hours later, I then saw them spraying. I didn't think anything of it.
We had plastic all over wrapped around everywhere. He got knocked on his door and spoken to let know that they were going to be spraying. So
I'm thankful that my car's going to get fixed.
that was the reason we knocked. I mean,
It was brand new. I had just had it for about a month.
maybe he's just lazy, didn't want to move it. I don't know.
It was in pristine condition.
People need to get their own jobs, you know what I mean? Instead of suing people
Not pristine.
for the hard-earned money.
We're just glad it's finally settled.
And now the next case.
Step forward.
Victoria and Norman Grover are suing former friend Robert Flink for vet bills after their Cocker Spaniel was injured on his property.
Mrs. Grover, what is your dog's name?
Rocky.
And how old is Rocky?
6 years old.
You were looking at some property, you and your husband. And the property was owned by Mr. Flink.
Yes, my family.
What kind of property is it, Mr. Flink?
It's an old single-family house with a detached garage.
On how much property?
The lot is 76 by 100.
Where is it located?
It's in Costa Mesa.
On what date did you go and look at the property?
June 24th.
Of this year?
Of this year, 2013, yes.
This is what your case is about. You went to look at the property. When you got to the property, the dog, Rocky?
Yes.
Rocky, who was leashed at the time.
Yes.
Someone took the leash off the dog. Who did that?
Bob Flink.
And you agree that you took the leash off the dog
Yes.
so the dog could run around?
I had brought my dogs there, too, since she had brought her dog.
What kind of dog did you have?
German Short-Hair Pointer that I got from the rescue about a year ago. And then I had my neighbor's dog, Henry, who was a Heinz 57 variety dog.
Okay. So the three dogs were sort of running around.
Yes.
And had you looked at the house?
Yes.
Did you like the house?
Yes.
Now, the accident that involved Rocky took place in the garage.
Yes.
Would you like to tell me what happened?
Shell incident.
No, start with, you looked at the house, you liked the house, and now you're outside, the dogs are running around, all three dogs, and when you tell me the story, keep your voice up a little bit because I'm...
Okay. So we were outside looking at the yard, and then Bob had showed us the garage, and there's 2 garage doors. And, Your Honor, I had learned that that garage was not going to be part of the lease, that we were not able to use that. So Mr. Flink opened up the first garage door.
When you open up the garage door, is that an automatic door?
I don't believe so.
How do you open the garage door?
It's a garage door that swings open, so you have to grab a hold of the handle in the middle and swing it out towards you, and then push it out open.
So you bent down, opened up the garage door,
Yes.
And so we saw there was, I believe, recreational vehicles there. It was filled up. So then he went to the other garage door. As he was opening that up, Your Honor, my dog, Rocky, ran in the same time that an iron pole of...
Similar to this.
Similar to this.
Put similar down.
Okay. The iron pole had fell and crushed his tail as he ran in.
Leaning up on the inside of the garage.
So when the dog walked in, he
he knocked into it, and then the pole started teetering over. It bounced off the wave runner that was in there and then continued on to the garage floor. I mean, making a scraping sound as it was going down and then the ringing when it hit the floor. And then Rocky was in that area. He ran underneath the jet ski trailer that was in there, and when he came out wagging his tail, it was
There was
bleeding.
only a piece of it left.
No, it was just bleeding.
Judge Judy continues in a moment.
What didn't you understand that I needed this additional explanation from you?
I just want to clear it up.
There's nothing that was unclear to me.
Okay.
Did I look confused to you?
No, you don't at all.
Real cases, real people. Judge Judy. Victoria and Norman Grover say former friend Robert Flink is responsible for vet bills after their Cocker Spaniel's tail was crushed while the dog was on his property.
So when the dog walked in, he
He knocked into it, and then the pole started teetering over. He ran underneath the jet ski trailer, and when he came out wagging his tail,
There was
bleeding.
only a piece of it left.
No, it was just bleeding.
Okay. So what did you do?
Got out 2 first aid kits, and Norm bandaged it up after Vicky had hosed him, and it just looked like a little cut in his tail. Couldn't tell what was...
Whatever. So you took him to the vet. The vet had to amputate a piece of the tail. Vet bill was
$998.
$998 that you want Mr. Flink to be responsible for.
Yes.
That's what the case is. Is that simple?
May I...
What did I miss?
Well, Mr. Flink said that he had ran into something to cause it to fall.
I don't care whether he ran into something or not.
Okay.
On the property, he took the leash off the dog.
Yes.
While you didn't protest that, he let the dog gain access to the garage. So, Mr. Flink, why do you not think that you're responsible for this vet bill?
Well, when I started to open up the garage, it was only a third of the way open when Rocky ran in. Then I had to change my hand position to open up the garage door the rest of the way, and the bar wasn't falling until the door was open and I could see what was going on. And it hit the wave runner, which I wouldn't have something propped up in there to hit the jet ski.
Just a second. Let us substitute a 2-year-old toddler for Rocky.
All right.
If a child was injured under the same circumstance on your property because there was a pole or something that was loose in an area, sufficiently loose so that the child was injured, why would you think you were not responsible?
Well,
Right, but you might have a puppy.
well, the other 2 dogs that were there, they didn't go running into the door. Only
Well, just a
Rocky
second.
there.
One of those was yours.
Yes.
Maybe yours is smart and knew about the loose pole.
It wasn't. It was propped up in the garage to where it was going to stay unless something happened to hit it.
It's your responsibility, sir, to see to it that your property is in order so that it's not going to hurt anybody or anything. Why would you open the garage door anyway?
They wanted to see if there was any storage room in the garage.
Well, let me hear. I'm just curious. What's that conversation? The garage was not being rented with the house.
Right.
So tell me about the conversation. Did you say to them, there really is no room for you to store your stuff in here? Let me show you. Is that why you opened the garage?
I opened the garage because they asked to see if there was any room in there for storage for bicycles or whatever.
And what did you say to them?
I said the garage was full.
So why did you open it?
As a courtesy to show them that there wasn't any room in there.
It's your property.
Judge Judy continues in a moment. Closed captioning sponsored by Real Cases, Real People. Judge Judy. Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
What did you open it?
As a courtesy to show them that there wasn't any room in there.
It's your property. In any event, can I see the vet bill, please?
Your Honor, by the way, that's not how it happened.
Well, I'd like to hear your version of how it happened.
So we saw the inside of the house. Fine. He brought
We're outside the house already. We're
outside
in
the
garage.
house, yes. And I said the garage is not included, correct? That's all I stated. I just wanted to confirm that. And that's when Bob went into action and he opened the garage door.
Explain that to me. I don't understand what you're saying.
I didn't ask to see the garage at all. We already understood that the garage was not a part of the rental.
Mr. Grover, what part of you won your case 5 minutes ago didn't you understand that I needed this additional explanation from you?
I just want to clear it up, that's all.
There's nothing that was unclear to me.
Okay.
Did I look confused to you?
No, you don't at all.
Judge, for the plaintiff in the amount of $988.11. Thank you.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
Mr. Simeone had your car towed. What you say is you parked legally.
But will a mystery witness put a dent in her story?
This is not going to be without pain.
I think I was right. It wasn't my fault.
I'm very pleased.
The dog banged into something into the garage, and that's what caused the bar to tip over.
He had said, sue me, and he hung up on me.
I got 2 first aid kits out of the garage, and Norm bandaged up the dog's tail after Vicky had hosed it off.
We sent him off with my wife to the vet as soon as possible.
The dog's tail was still bleeding.
They had to do surgery to find out if they could stitch it up or if it would be amputated.
If something hadn't been done, it would have just kept bleeding.
With that type of an injury, he just would have bled to death.
What were you doing driving it without insurance?
Well, to be honest, I didn't really know.
Unsafe and out of control.
Out of nowhere, I heard a big bang. I just swerved. Left, right, I'm holding the wheel. I hit the mailboxes. I swerved to the left again.
And an unseen victim is mourned.
Your car hit her dog and killed her dog.
This is Judge Judy. 18-year-old Kevin Rodriguez is suing Lacey Migliori for damages to...
Judge, this is case number 150 on the calendar in the matter of Rodriguez versus Migliori. Parties have been sworn in. Ma'am, have a seat, please.
Thanks, Bird. Mr. Rodriguez, It is your claim that the defendant's dog, while out of her control, caused an accident with your car, which damaged your car. Your car hit the defendant's dog and killed the defendant's dog. But then it is your claim that after that impact, you lost control of the car, causing damage to the car because you crashed into something else. The defendant says that while she did not see this incident, is that correct?
That's correct.
That the dog was on their fenced property when this incident happened. You lost control of your car. You crashed through the fence in the house where the dog was. I don't know if it's your house or not, but it was the dog was in a fenced area. Just a second.
Okay.
That's what she's claiming.
Yes.
That the dog was killed on property. Is it your property or someone else's?
We were displaced from the creek fire, and we were staying with my Nana at my Nana's house.
Okay. Is that your grandmother?
Yes.
So it as ostensibly, for all intents and purposes, at her house. She says that the dog was killed on the property where she was staying, and it was fenced property and killed her dog. That's your statement, although you didn't see the incident happen.
Yes.
Is that right?
Yes.
Okay. This incident happened on what date, Mr. Rodriguez?
On September 20th, 2020.
What time?
It was around 6 p.m.
6 p.m., and you live in California?
Yes.
So is it dusk at that time?
Yeah, I could say it was dusk.
Tell me what happened, sir.
Okay, so on September 20th, I was driving to my friend's house.
Look at me. Don't look at...
Don't look at none of this?
Don't look at your papers.
Okay.
I want you to look at me and tell me what happened so I can look in your eyes.
Okay. So on September 20th, 2020, I was going to a friend's house. I live in Clovis, so that's about 18 minutes away from my friend's house. So there's a street on Sanger that you have to go on. It's called Academy.
Could you look at me?
Yeah. I was going on Academy, and you have to turn right on Shields to go to my friend's house. I turn right on Shields. I see a school pass by, so I think, oh, in my head, go a little faster, after we pass the school.
There's a school.
There's a...
Look at me. Don't look down. Look up. You saw a school.
Yes.
Okay. And this was 6 o'clock, so you...
Because I passed the school, so the speed limit it's the regular speed limit, right? After you pass the school.
Okay, so you had slowed down?
Yeah, when it was at the school, I slowed down because I saw the 25, right, speed limit. I passed by, I saw that it was 55. I speeded up.
Look at me. Don't look down.
Sorry, I'm
sorry.
Look at me. I speeded up, and then I was passing a couple houses, and then right at when I got to the defendant's house, out of nowhere, I was just driving, I was 55 miles per hour. I was driving normally, right? Out of nowhere, I heard a big bang. Bang, and then I just swerved. Go left, right, I'm holding the wheel, trying to,
I got it.
Try to gain control, and I just keep swerving, and then I finally get to the mailboxes. I pass the street that was right here, and then there's the mailboxes at a different person's house. I hit the mailboxes, I swerve to the left again, and I try to control again, and then at some point I just braked, and I was able to go to the side of the road, and I saw a few people come back behind me. There was a truck with 2 gentlemen. They told me that I hit something big.
Don't tell me what they told you.
Okay.
Did you get out of the car?
Yes.
Did you get out of the car?
I got out
assume you got out of the car. And so what you're saying is that the dog hit the side of your car, or did you run over the dog?
So it hit the right side of the car because on the pictures, you could actually see where the impact was, so...
I'd like to see the picture, please.
It's right here. Right here, you could see. Right here was the impact.
Okay. This is a residential area,
yes.
Mr. Rodriguez?
Yes.
Do you have a photograph of where it says in this residential area it's a 55-mile-an-hour speed limit?
I do not, but on the report it says I was going on the speed limit 55.
Oh,
yeah.
So the report says it's a 55 speed limit. Okay.
Would you like to see that?
I would. Thank you. Okay, could you go to summary, please? I'd like to see the summary. Thank you. Okay, is there any other part of that report?
Yes, there is one more page.
I'd like to see it. Did you speak to the police that day, Miss Migliori?
I did. He wasn't very nice.
I didn't ask you. Just a second. Just answer my question. Did you speak to the police? The answer is yes.
Yes.
When you spoke to the police, was the dog's body still in the road?
No, the dog's body was never in the road. The dog's body was wrapped around a pole and in the barbed wire fence.
Just a second. The dog's body, show me so that I understand where you say the dog's body was.
Her body was wrapped around this pole, and her whole chest was cut open by the barbed wire. So her head was this way, pointing towards the road. No. And then the back of her body was...
Well, I don't know. I know that that's what you're telling me. Whose barbed wire fence is that?
That is my Nana's.
That's where you were staying?
Yes.
And is what you're saying his car came through there?
Well, because, okay, she's
not a well. Is what you're saying...
Yes.
That the car came through that fence. So now I would like to see a picture of the downed fence. The downed fence.
The fence wasn't down.
Well, his car didn't fit in between the slats.
Right.
So the fence had to be down. That's what you wrote here, that he came through.
Right.
He came through the fence. So if you're telling me that the fence didn't come down, that means that the car didn't go through the slats of that fence, because you would have taken a picture of the down fence.
Right.
Yes.
Yes.
Right. Yes. Can you show me a picture when you finally got out, Mr. Rodriguez, because now she's playing with me. When you finally got out of your car, you went back to where the dog was?
I did, yes.
And where was the dog?
So the defendant's family came running to me after the...
No. Where was the dog?
The dog was with the defendant.
With the defendant?
Yes.
So when you hit the dog didn't die immediately?
I believe it died immediately because I was going 55.
Okay. So when you say the dog was with the defendant, where was the defendant and the dog?
Defendant was with the dog after the incident.
Where physically?
Oh, where?
In a yard, in a street.
Oh, it was right at the side of the road. I saw the fence right there, but I did not hit any fence or nothing. I didn't...
No, a fence didn't go down. That was a lot of baloney. And your car didn't go through the fence because it was not a very thin car. So she was sitting at the fence on the other side, on the street side of the fence with the dog?
Yeah, I think she was sitting with her dog after the incident happened. And she seemed really sad.
Upset?
Upset, yeah.
Well, understandably.
I understand, yeah.
Okay, now, can I see, please, estimates for the damage to your car?
Yes, I have the receipts right here, actually. I believe there's 2 pages.
And you had the car?
Yeah, we had the car fixed already.
How much was it to fix the car?
The grand total was...
This is 2011 Acura?
Yeah.
The grand total was $4,600?
Yes.
You have insurance?
Yes, now I do, yes.
Did you have then?
So,
So the answer is either yes or no?
No.
You neither had collision nor liability?
No.
Judge Judy continues in a moment.
In what month and year did your insurance lapse?
On July.
What were you doing driving it without insurance?
The insurance...
Don't give me baloney that you didn't get notified. I don't believe it.
And later today...
Believe it or not, even with the ballerina at one point in my life. When I stopped growing, he was quickly disabused of that notion.
Closed captioning is provided by... Kevin Rodriguez says Lacey Migliori is responsible for damage to his car after he struck and killed her unleashed dog.
Okay. How long have you had this 2011 Acura?
I want to say more than 8 years, 7, 8 years.
And in what month and year did your insurance lapse?
On July.
What were you doing driving it without insurance?
The insurance.
Don't give me baloney that you didn't get notified. I don't believe it.
Well, to be honest, I didn't really know. I had took the car. I just wanted to go to hang out with a friend, you know.
What do you mean you didn't know? It's your car. Is the car in your name?
The car is under
the
my
car in
aunt's
your name?
Under my aunt's name. Yeah.
Gets better all the time. Okay, your case is dismissed, Mr. Rodriguez. You don't come to court and ask for a court's help when you don't have clean hands. Clean hands. Otherwise, she would have paid for the damage to your car because it would make sure that her dog didn't cause any injury. That was her responsibility. But it is the height of what we say in French, chutzpah, to come to court and ask a court to help you when you've been doing the wrong thing for at least 2 months, driving a car without insurance. If you hit somebody and kill them, they would have nobody to sue. You would say, oh, it's not even my car, it's my aunt's car. Goodbye, Mr. Rodriguez. Get insurance. Goodbye. Thank you very much. You're very lucky, Ms. Migliori.
This case is concluded.
Thank
Parties
you.
are excused.
Dog out of nowhere. Swerve. Scared out of my mind.
I feel like he swerved into my dog because he wasn't paying attention.
I will pay more attention.
I was over her body crying, and the first thing he says to me was, "You're gonna pay me, right?"
I now have insurance, so.
If I ever get another dog, and make sure that she's on a leash.
And now, the next case.
All parties in the matter of Ely versus Ladd step forward.
Dance teacher Amber Ely is suing the mother of a former student, Jennifer Ladd, for unpaid tuition and recital fees.
Miss Ely, you have a dancing school. Miss Ladd's daughter was a student of yours, and it is your claim that Miss Ladd owes you for several months of schooling that you gave to her daughter, and also for some costumes and I don't know what she says. I'm not exactly sure. When did your daughter enroll in Miss Eli's school?
3 years ago.
And what is the cost per month or per year?
It varies. It's $60 a month.
Okay, is that what you were paying 3 years ago?
Yes.
When did your daughter leave the school?
June 29th.
And she goes once a week?
Yes.
I know a little bit about dancing school and recitals and stuff, even from my own growing up days, because believe it or not, even with these relatively short legs, my father thought I could be a ballerina at one point in my life. When I stopped growing, he was quickly disabused of that notion. Not before I spent many, many years at Miss Nottage's dancing school, so I'm aware of the way dancing schools work.
Judge Judy continues in a moment.
All she had to do is bring the debit card, register.
Well, she tried to. She gave her the debit card.
Sit. She knows how to speak English as her primary language.
Real cases, real people. Judge Judy. Dance teacher Amber Ely says the mother of a former student, Jennifer Ladd, owes for unpaid tuition and recital fees.
Now, I know sort of work all year, and at some point the kids put on a recital and they get nice costumes and everybody comes and takes pictures. Now they take them with iPhones. They used to take them with huge cameras. You have to sit through what is boring for most people, except when their child is on stage or their grandchild is on stage, being a tomato or a fairy or a moon or a sun or whatever it is. I also know that you pay additionally for those costumes and sometimes for the tickets or whatever. It's a way of the school making additional money. Was your daughter in a recital in the first year that she was there?
Yes, she was.
And did you buy a costume?
Yes.
And was she in a recital the second year you were there?
No.
Was she in a recital the third year she was there?
Yes.
Did you buy her costume?
Yes.
Did you pay for it?
No.
It's going to be much easier this way. So you didn't pay for the costume the third year, because that's part of her lawsuit. And your daughter did use the costume. Do you know how much she charged for the costume?
The total bill that month was $400.
How much was the costume?
The costumes were $210. She wore 3 of them.
Okay, so that's $210, and they were not paid for.
No.
Got it. She says they were not paid for. And do you claim she did not pay?
It's actually $65 a month. And she owes a registration fee. She paid the registration fee. She came in November.
Just answer my question, please.
April,
What
May,
months?
June. April, May, and June.
Was she in class April, May, and June?
Yes.
When was the recital?
June 29th.
And she participated in that?
Absolutely.
Why didn't you pay April, May, and June off for the costumes?
I gave her my debit card, and she said I was all set when I was in the dance studio when I paid my bill. 2 months later, she called me back and said my credit card machine wasn't working. And I said, so...
Now, Miss Ladd,
sorry.
Before you get yourself really in a pickle,
right?
Did you pay her?
Yes.
Pay her?
Yes.
For April, May, and June?
Yes.
Show me your debit card where either $60 or $65 was taken out, April, May, and June, and then we resolve it. Then you only owe her the $210 for the costume. Just show me your debit card.
Well...
Not a well. That's a very easy thing to show.
I paid cash.
No, you said you gave her your debit card.
That was for the big bill that she told me I owed.
So the answer is you don't have proof that you... That correct?
That's correct. I have a receipt here for...
Do you have a receipt for April, May, and June?
No, sorry, this was for July.
Can I say something?
Who are you?
I'm her friend. I've taken her daughter back and forth to the dance and...
Listen to me, stand up. This is why you can't say anything.
Judge Judy continues in a moment. Closed captioning sponsored by Real Cases, Real People. Judge Judy. Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Listen to me. She's already admitted that she didn't pay for the costumes. She knows she's supposed to pay for the costumes. She's paid for the costumes before, and her daughter used the costumes. That's $210. Plaintiff says despite the fact that she was in the school for 3 years, she says only that she didn't pay for April, May, and June. Very easy. You don't know what she signed in her answer. I have it right here.
Well, I mean...
Listen to me carefully. All she had to do is bring the debit card, register, that indicates April, May, and June paid. Either $60 or $65 a month.
Well, she tried...
She knows how to speak. English is her primary language. You owe her $405.
Yes.
That's $210 for the costume.
Yes.
And the balance is for April, May, and June.
Yes.
Your daughter no longer goes to the school?
No.
Good. Thanks. Bye.
Excuse you may step down.
Thank you, Your Honor.
Judge Judy continues in a moment. And on the next Judge Judy.
This is a lecture, and I don't want you to interrupt me.
I get mad because...
What part of don't interrupt me don't you understand? You are not going to overtalk me, ever.
Judge Judy.
I thought it was very fair. There's a lot of other things that she does owe me for, which is I'm just going to kind of wash it as of now.
A lot of miscommunication in the dance studio for the 3 years. Not with just me, with a lot of other moms as well.
I have parents that take it out on me because they can't pay their bills, which is part of being a business owner.
She lost all of her clients. She lost all of her students.
I didn't lose any students.
She wasn't learning anything.
I did enjoy Bella as a student, but she wasn't consistent. She wasn't in every week like the other children.
When you go and you have your child in a dance class, you expect them to learn something. After 3 years, nothing was taught.
I did hire a teacher to teach her daughter in the back of the room, so she would do that. So she should be thanking me instead of upset that she owes me money.
She'll dance somewhere else.
He was told he was fired.
That work that he did was not proper at all.
Blood boils over a kitchen remodel.
Mr. Gonzalez did substantial work in your house. Okay, but me no buts.
Is the controversy all cooked up?
Did you have to rip out the old kitchen?
Yes, they demoed the kitchen, but carefully.
I'm not questioning that. I'm beginning to question their lawsuit.
This is Judge Judy. Daryl and Belinda Flournoy are suing carpenter and former neighbor Javier Gonzalez for the return of money they paid him to make custom kitchen cabinets.
Judge's case number 155 on the calendar in the matter of Flournoy versus Gonzalez. Parties have been sworn in.
Thank you, Bird. Mr. and Mrs. Flournoy, you and Mr. Gonzalez knew each other. You were neighbors and friends for a while. And his business is in construction, or remodeling houses?
He's a contractor. He builds cabinets. He's a cabinet maker.
Great. Here, you reached out to Mr. Gonzalez. You entered into a contract with him, according to your complaint, for $12,000, $6,000 deposit. That was made in July. He was supposed to be finished in September.
Yes.
Great. And at some point, according to you, Mr. Gonzalez breached the contract by not coming back and completing the work. Yes. Mr. Gonzalez said in a conversation with your husband that he was told that he was fired. That's what he says. Mr. Gonzalez is counterclaiming for money, materials, labor, and installation of what he already did. So I have several questions. This happened back in September. He finally stopped coming back to work in September. And you've been living in the house since. So I assume you had the kitchen completed.
Yes, ma'am.
By whom?
Another contractor that was referred to us.
And what's the name of that contractor?
His name is Danny.
And when did he start working on the kitchen?
In October.
Because I am assuming that for the purpose of this, the kitchen was not completed by you, Mr. Gonzalez. Is that correct?
Yes, that's correct. All I needed to do was hang doors and put in the drawers and the pull-outs.
Whatever you had to do, it wasn't totally completed by you. Is that right?
Yes.
Okay. Did Mr. and Mrs. Flournoy have all the materials in their house? Did you ever provide them with the doors?
No, the doors were still being fabricated.
Oh, just a second. So the answer is you never provided them with doors?
No.
Did you ever provide them with the drawers?
No.
What else didn't you provide them with?
That was all that was left. Was just the doors, shelves, and the pull-outs.
And the drawers.
And the drawers, yes.
Just a minute. Did all of this cabinetry have to be painted once hung?
It was painted prior to being hung. Stained.
Was that a final stain of what they selected, or did it have to be painted over?
No, it was a gray
Wood.
stain over alder, and it had a satin finish, clear coat, sanding sealer and clear coat.
That was what was there, what you put in?
Yes.
Ms. Flournoy, do you have a photograph of what the kitchen looked like just prior to the new contractor starting work?
Yes, ma'am.
I'd like to see it.
There's one picture.
Show me the whole kitchen.
This is another angle there. Here is the top angle.
Okay.
That might be the last one that I have.
All right, so I see shelves. I see some of them painted, and that the one that's painted was probably going to be an open.
It's pre-finished birch, so it's got a lacquer finish on it.
Okay, my next question, did you have to rip out the old kitchen?
Yes, carefully we took them out. I had a demo guy take them out so that they can use them in another part of their home. Yes.
Just a second. The $12,000 included demoing the kitchen, taking the shelves out, and did somebody else put them in someplace else in the house?
No.
Or did you?
No, we put them in the backyard. They were on the back porch. They wanted to reuse them in different parts of their home.
Okay. But you took them out?
Yes.
So you demolished the kitchen as well?
Yes, they demoed the kitchen, but carefully with minor damage.
I'm just asking.
Oh, okay.
Yeah.
Sorry.
I'm not questioning that. I'm beginning to question their lawsuit, not you.
Okay.
Now, so it's clear to me that Mr. Gonzalez, Ms. Flournoy, did substantial work in your house. He demolished the kitchen, took out the old cabinets. He clearly constructed new cabinetry in the kitchen, some of which is clearly stained to a finish. Now I would like you to show me, just show me, a photograph of your currently finished kitchen after you had Mr. Do it.
Okay.
Just show me a picture of the finished kitchen. Great. He purrs and he put in the end cabinet, which had been stained.
We
he
had
put
to have
in
them restained.
a light. That's your problem.
When Mr. came, he said, "Is this supposed to be the finished color?" We said, "No." He said, "It doesn't look finished. It would need to be repainted."
Very blotchy. It was very spotty.
Let me, just a second. Let me explain something to you. A, you can't tell me what Danny said to you because that's hearsay.
Okay.
B, if you change the color, that's your problem.
We didn't
I want to
change
see
the
an
color,
itemized bill. Yeah, I didn't hear any complaint from you about color in any place in your complaint. Did you complain that the color was not the color that you wanted? I mean, he put these cabinets in at different time periods, not all the same day.
Yes, it was all the same day.
Ms. Flournoy, put up the itemized bill that you got from Danny.
My argument is that you're saying that Mr. Gonzalez put up the cabinets in different stages. There was one day, and he had a worker do that.
No, that's not my argument. I don't care whether that's true or not. I want to know how much he charged you. We proposed to furnish materials for $5,500.
Yes.
So he completed the job for $5,500. I'm just trying to wrap my head around your request for $5,000 back from the defendant.
Okay.
Danny finished the job for $5,500. You paid him $6,000 as a deposit to do the kitchen.
Yes.
Clearly, he did substantial work in the kitchen, demolished, whatever the reason, whether he was fired or not fired or whether he just didn't come back. So far, you're paying $11,500 and you got a finished kitchen. The original price of the kitchen was $12,000.
Okay.
So if I give you, you're not paying attention. So if I give you $5,000 from him, you got a finished kitchen for $5,500, including demolition. You think that's reasonable?
I do, because Javier's quote included, the contract that we signed, it included for him to do the demo and complete the project, which he did not do. Also included for the backsplash to be replaced. It had to be replaced because of the length of the cabinets, the extension of it. That was included in Javier's quote. That was never done under Javier.
Just a second.
Yes, ma'am.
Just a second. I'm just asking you, is that backsplash paid to Danny?
No, ma'am.
So you have an additional bill for the backsplash. Let me see it.
Okay, so this is the invoice for the labor that was done from the original contractor that had already installed our countertops, and Javier was working with him. And since Javier did not complete it, they could not find the backsplash because Javier had never ordered it, and therefore we ended up having to
Ms.
have.
Flournoy,
yes.
Did you have a backsplash put in?
This is the $500 for the labor to the gentleman, his company, that did so, and we purchased.
Just tell me how much the backsplash was. $500?
$500 for the labor to Johnny, who Mr. Gonzalez knows, and then we paid $300 for the tile for the backsplash.
You're still under $12,000.
Yes, ma'am. However,
For a whole kitchen.
There's also the island that Mr. Gonzalez had made the end caps, which he brought and left at our home. He was supposed to install those on the end of the island to make that island look just like the cabinets. So I was not in there when he brought these, but this is a picture of the end caps still not installed, because on one of my messages to Mr. Gonzalez, and having to lift up the island, the countertop, because it could possibly break. He says in his response to me that he didn't think that that was going to happen, but if it did, he would replace it. So when Javier brought these end caps, it didn't fit, and he just left them there. So the island was never completed. Mr. could not figure out.
Danny should have completed.
Well, he could not figure out
what. You have a completed kitchen. You're not getting a kitchen for $5,000. That's not happening.
And the cabinet work that he put up there is not worth $5,000. He bolted some shelves up there. They had large gaps that was not fitting properly at all. So the photo you're seeing there, that work that he did was not proper at all. I would not have settled that.
We tried to have other people come in and complete the work, and then we found Mr. Holquin. He was a recommendation to us from the countertop gentleman. We have that done, but there were still components, not to mention Mr. Gonzalez and me and my husband, we discussed penalties for each day that he did not complete the project timely. And he told us that his rate was $200, but we would not have to worry about that. He was supposed to be done on the 3rd. We were literally had to buy a new microwave. We could not use our kitchen at all.
And he did nothing to try to compensate us or even cared about how we was living.
That's what happens when you do construction. And I'm telling you right now, there's a certain fairness. And if I were to take from him $5,000, that means that all the work he did in
Which
your
was
house,
not $6,000 worth of work.
Well, that's for me ultimately to say he did more more than $1,000 worth of work in your house. And I'm not a contractor. All I know is you got a kitchen done. Don't interrupt me again.
Judge Judy continues in a moment. And later today.
So let me understand this. He sliced your face open and you sought no medical care. Is that what you're telling me?
Closed captioning is provided by Daryl and Belinda Flournoy claim carpenter Javier Gonzalez left their kitchen remodel incomplete. Javier is countersuing for material and labor costs.
Now, he did more work for you than $1,000. And if I were to grant your petition and give you $5,000, that means he spent time demolishing your kitchen, building cabinets, staining cabinets, actually you're being unreasonable about. So your case is dismissed, as is your counterclaim, sir. We're done. Thank you.
Thank you.
This case is concluded. Parties are excused.
It started falling apart because he is unreliable and all he wants to do is go around and populate the earth with children.
When they went wrong is when they drink. They get intoxicated and then they want to try to handle business, and it's not good because she is crazy.
He kept committing to doing so and he just never showed up, never did any of it.
We're talking just days that I was late. I made my promises and I stuck to them.
Very frustrating. He was a friend.
Yeah, most definitely I wanted to complete the job. Not for finances.
This time, I had got fed up with it. I said, man, you tore my whole kitchen apart.
But for friendship. But unfortunately, Dee, it didn't work out that way.
When she didn't want to deal with him anymore, and I still gave him another chance, and he left me high and dry.
And now, the next case.
All parties in the matter of Seno versus Rademacher step forward.
Amateo Shino is suing his former live-in girlfriend, Lisa Rademacher, for the return of a coin collection taken from his safe. Lisa is countersuing for medical bills as the result of an assault.
Mr. Seno, the defendant is your former live-in girlfriend. Your lawsuit is about some coins. You and the defendant had an argument, and according to you, you picked up something, a soap bottle, in anger, and you tossed it, and unfortunately it hit the defendant in the face. According to you left the house in order to cool off, and at some point later you came back, locks had been changed, and when you finally did get back into the house, you found that the little safe that you had where you kept these coins was open and the safe was empty, coins were gone. The defendant says that she did in fact take your coins, but you told her that she could keep your coins because it was just before the rent was due, so she had to cover the rent, so you told her to keep the coins. She has a counterclaim for the assault, and what she says will be the necessity for plastic surgery on her face to get rid of whatever scar is there, which I'm sure that you'll show me, and you'll show me what the report is from your plastic surgeon. So why don't we start with you, Ms. Rademacher. This argument took place on what date?
It took place on August 30th.
And I'd like you to tell me about the assault portion of that argument.
Judge Judy continues in a moment.
What I'm going to say to you is going to make my life much easier, so I don't even have to stretch my muscles.
Real people, Judge Judy. Amateo Shino says former live-in girlfriend Lisa Rademacher stole a coin collection from a safe inside his home. Lisa claims she used the coins to pay rent after Amateo assaulted her and fled the scene.
Go ahead.
Well, he was upset. He's very jealous, and so he got upset, and he called me stupid and picked up a soap bottle and just threw it right at me, and it hit me right in the face and sliced it open.
Show me where the cut was, from where to where?
From, like, right, I can't see, but, like, from right here to here. I have a picture of it.
I'd like to take a look at the picture. Okay. And what
That's
time
before,
of the, what
and this
kind
is
of
after.
the day, what kind
I'm
of
getting
the,
healed.
Pay careful attention. What time of the day?
That's before, and the other one's after. It healed.
I mean, do you take medication? Do you take any medication?
No.
Good. And try to pay attention to what I'm saying to you.
Okay.
I ask the questions, you answer the questions.
Okay.
What time of the day or evening did this happen?
It was in the morning.
What time?
Around 10 a.m.
Had you both slept at home when you both woke up?
It had actually started the night before.
Yes.
We had gone out, and he gets jealous, like if other men look at me or things like that. So he was already like revved up from the night before. So in the morning, he just got out of control.
It continued. Okay. I'd like to see the medical report that you have.
Yeah, I don't have a medical report.
What do you mean you don't have a medical report? You say you need plastic surgery.
Yeah, just to remove the scar from, because I already have a plastic surgeon. And
how am I supposed to figure out how much that is?
Well, there's a lot of different factors, but if you get anesthesia, so I just did the lowest possible, like, estimate, which was like $3,200. So.
All right, Miss Radmaster, so let me understand this. He sliced your face open and you sought no medical care. Is that what you're telling me?
No, I don't have insurance, so.
You don't need insurance to go to an emergency room if somebody slices your face open. Do you have a police report?
Yeah, I do.
I'd like to see it.
I don't have it with me.
Well, where is it?
It's at home.
Why is it at home?
I was in a rush this morning.
Okay.
Oh, okay.
Don't think about what you're going to say to me.
Okay.
Where are his coins?
They're spent.
Oh, they're spent. Well, if you spent his coins, then you get nothing on your counterclaim. How's that? How's that?
Well, that was for rent.
How's that? You spent his coins, you get zero on your counterclaim. Whatever his coins were worth, that's what I was going to award you on your counterclaim. Because I don't actually buy either one of you. I think you're both either loaded or I don't know what. I have no idea what.
Judge Judy continues in a moment. Closed captioning sponsored by Real Cases, Real People. Judge Judy. Are you the victim of an assault? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
So, this is the story, sir. You tell me that the coins are worth $5,000, probably worth a lot less than $5,000, because I don't think you actually have any proof of what you paid for them that I'm going to believe. So, what I'm going to say to you is as follows, because it's going to make my life much easier, so I don't even have to stretch my muscles. I'm awarding you, sir, $5,000 for your coins. I'm awarding her $5,000. Nothing. Goodbye.
Parties are excused and they step out.
Judge Judy continues in a moment. And on the next Judge Judy, a roommate moves out.
All of the bills were in my name, so she owes me for all of them. She had an altercation with the other roommate.
Absolutely not.
Let's get real.
Judge Judy.
Obviously, I have a scar. I suffered. I'm a girl.
I'm a little jealous at times.
Girls, if they get scars or anything on their face, it's very, it's traumatizing.
And out of anger, I did throw something at her. I had my part in this.
It was like a gash. I don't have medical insurance, and it was a gash.
I mean, love is not a light switch for me. I can't turn it on and off that easily.
I just think that he needs like anger management, and he just has a, anger problem.
I have feelings for her, but I'm really upset with some of her choices and how she, lives her life.
I just can't. You can't put up with violence.
A roommate moves out.
All of the bills were in my name, so she owes me for all of them.
But she can't move on.
She had an altercation with the other roommate.
You're getting a dog that she complained about.
Yeah.
You could not get your car out. And you also think she's responsible for that.
Absolutely not.
Let's get real.
This is Judge Judy. Caitlin Zimbardi is suing her former roommate, 24-year-old Brittany Hill, for rent, utility bills, and damage to her car. Brittany is countersuing for harassment and emotional distress.
Judge, this is case number 148 on the calendar, the matter of Zimbardi versus Hill. Parties have been sworn in. Ma'am, have a seat, please.
Thank you, Bert. Ms. Zimbardi, the defendant was a roommate of yours.
Yes, Your Honor.
And it is your claim, she's no longer a roommate of yours, that she owes you for rent. The rent you are alleging she owes you was someone else's rent. You understand that it is your claim that the defendant had an argument with one of your other roommates. Because of the argument, which you believe she initiated, the other roommate moved out, and you believe because she was responsible for that argument, she should pay that roommate's share of the rent.
Yes, Your Honor, that's true.
Am I getting that right?
Yes, Your Honor.
That's your first claim.
Correct.
Your second claim is your roommate. She parked her car in such a way that you could not get your car out.
Yes, that's
of
true.
Your parking spot. I'm just trying to get this all down right. You knocked at her door to tell her to move her car. She did not respond. So you went back to your car and tried to maneuver around her car and broke your mirror.
Yes, that's
in
what
the
happened.
process.
Correct.
And you also think she's responsible for that.
Yes, because if she
so
wouldn't
those
have
are the two things.
Yes.
Yes.
If she would not have been parked behind me, I could have gotten out easily.
And your counterclaim is that she made your life miserable as a roommate.
Yes, Your Honor.
Something about you getting a dog that she complained about, and I don't care. Neither does the law.
Right.
Okay, whether she reported you for having a dog and that would upset you, and nobody cares about that. So your counterclaim is dismissed. I'm going to dismiss your claim as well, but I may let you tell me
additional
why you
claims.
why you think she's responsible for your other roommate's rent. Okay?
Yes. It was considered a
5 minutes of my time.
Okay, the rent was considered 1st of 2019. None of us had known each other. And in that 2 weeks, she had an altercation with the other roommate. She had texted her she doesn't want her to move in, even though we tried to have a conversation about making things smooth so we can continue living together. I have text messages showing that she told her, I don't want you to move in, and I don't like you. You have a bad attitude. And from another roommate, which the same thing happened, that she was speaking to Brittany. She got bad responses from Brittany. She was rude to her, and she also didn't want to move in. And so then when the rent was due, I was the one who had to cover the $1,100. She said that because it was her fault that she would pay me back for it.
Well, I'd like to see somewhere, because do you acknowledge, Ms. Hill, that you agreed to pay her back for roommates that didn't move in?
Absolutely not. I'm not a subletter.
Okay,
I'm on the lease.
Listen to what I'm saying. Just answer my question.
Sure.
Do you have anything in writing from her where she acknowledges that she will pay the rent for other people because they didn't move in because she said she didn't like them?
No, I don't have that in writing. I do have the in writing of her telling the roommate not to move in.
I don't need that.
Okay.
That's not an issue.
Well, it is a household rent, and our landlord has claimed time and time again that we're all responsible for the full amount.
Well, you are, but she doesn't owe you for anything. She owes the landlord. So now let me understand this. I just want to understand. The other roommates didn't move in. She doesn't live there anymore. Is that right? She doesn't live there anymore.
She just moved out this
month. Or does she?
No.
Up until the time she moved out, was she paying her rent?
No, she stopped paying rent in March of 2020. That's not part of the claim. I'm at my main claim request is back owed utility bills.
All right. Well, then let's get real, because she doesn't owe you for somebody else's rent, and she doesn't owe you because you couldn't back out your car.
If that was even true.
That's on you. You got to take responsibility. Just a second. I don't need your help. I've been doing this job a long time. If you, because of your misjudgment, have an accident, that's on you. That's not on her because she didn't move her car.
I understand, Your Honor.
Okay. Now, what you're suing her for, if what you're telling me is utilities, up until last month was, she moved out in November? November what?
I moved out December 5th.
Okay. And what utility bills are you referencing specifically?
I have 2 LADWP bills, 1 SoCal gas bill, and 1 Spectrum bill, all of them.
And during the prior time that you were living there, I assume that there were 4 roommates altogether?
At times 4, at times 3, because of COVID, 1 had moved out.
So she owes 25% of the utility bills. What are the total of the utility bills that were outstanding through December 5th that she didn't pay?
She owes $531.61.
I want to know what the total was of the utility bills through when she moved out December 5th. Not what you say her share is. My question was specific.
Well, I moved out in October, so that's when the bills are from.
You moved out in October.
Yes.
Leaving her there, and she didn't pay rent until March. Okay, so now let me see the utility bills. You acknowledge, Ms. Hill, that they were all in Ms. Zimbardi's name.
Yes.
And you are responsible for 25% of whatever is due and owing on those utility bills.
Yes, Your Honor.
Correct?
Correct.
Okay, so now let's see the final invoice of the utility bills. Give me the amount so that I don't have to look at it. The total amount due and owing on your last bill. First, the date of the first bill.
Well, the first bill was from September, and that's the total amount.
Remember, you were all living
No.
there in September.
She didn't pay that.
When was the last time you paid a utility bill?
The last time I paid was in August.
Hill.
In September, I told her that I had to get my car fixed. My unemployment was backed up.
Okay, so she owes 25% of $1,030.
Well, I have 3 more bills.
Just a second.
Okay.
So far.
And at the time, there was only 3 of us living there. So we each paid a
I don't
third.
care.
Okay.
Okay, what's next?
The other LADWP
What's the next
bill
bill?
was the final bill after I moved out we received, because it's a quarterly bill.
Okay, hold on. What's next?
This is our SoCal gas bill from that month.
What's next?
Spectrum bill, our internet, $65.
Next?
That was the last one.
Great. Judgment for the plaintiff in the amount of $365. Your counterclaim has already been dismissed. This case is over. Thank you very much.
Thank you, Judge.
Thank you.
This case is concluded. The parties are excused.
I think I was just living with a crazy person for the past year.
She has no goals in life, so maybe that's why there's so many problems between us.
She got an untrained puppy that she wouldn't clean up after.
He's completely fine and just needed some training like any other puppy does.
I'm definitely gonna do better vetting job.
I'm glad to put this.
Bergeron, step to the podium, please.
Thomas and Marcy Savage are suing Trent Bergeron for failing to pay for 2 bird cages.
Mr. and Mrs. Savage, this is what I understand. Both you and your husband, as well as the defendant, are collectors of exotic birds. Had that as a hobby for many years. For some reason, you decided that you were no longer going to pursue the hobby, and you had acquired over the course of this hobby bird cages and a large outdoor aviary in your backyard, which is just a huge bird cage. Do you have photographs of those things, by the way?
Yes, we do.
May I see them, please? Just so I can get an idea of what I'm talking about.
Here's a picture of one of the cages that was purchased.
And you had 2. Were they similar?
The second one is larger and has, let me put this one down. And the other one looks like this, yet it's white and it's larger, but the structure and
now, you bought these cages new, I assume, for
Yes.
your large birds. Now I want to see a picture of the outdoor aviary.
This is current day aviary.
December of 2019, when you met the defendant. Defendant is also a collector of large or exotic birds. According to you, he agreed to buy 2 of the large bird cages, the ones that you showed me that were inside of your house, and he agreed to buy them for $1,000. He came, he picked them up. He didn't have the $1,000. He gave you his word that he would pay you $250 a month until it was paid off. You didn't know him from a hole in the wall, but you agreed to that. Didn't hear from him for a long time. Finally, he got in touch, and he sent you $100. In total, over several months, he sent you a total of $300, and then nothing else.
Judge Judy, we received
yes.
$200.
Only 2?
Yes.
$200.
That's correct.
Right. First payment was missed. He said his daughter needed braces. He missed another payment. He said, claimed his wife Ann had a stroke. December, he sent you a payment, and he sent another $100 the end of January. And then he just stopped paying for them.
Judge Judy continues in a moment.
When you picked up the cages,
It was supposed to be
how much was your agreement?
$200.
And when were the payments supposed to start? Is not an answer.
Claude. Thomas and Marcy Savage are suing Trent Bergeron for failing to pay for 2 bird cages.
Okay. Now, the defendant says that he agreed to take the 2 cages and the outdoor aviary. And then a lot of excuses, a lot of reasons, and then COVID hit, and he said, just forget it. We don't want that big outdoor aviary, which looks like a piece of junk anyway. When you bought the 2 bird cages, do you recall how many years ago you bought them?
Approximately in 2001 on one of the cages. Later on, we replaced it with another cage in about 2010 or 11. But these were all indoor.
I want to know what you paid for the 2 cages that the defendant took.
One of them we paid $900 for. That was the beige large one. The dome cage we paid approximately $698. Now, there was a third piece that they had taken, which was a wrought iron indoor perch.
It was a standing perch for feeding.
And how much did you pay for that?
That perch was $298.
Okay. And all of these things were purchased over a 20-year period. Is
Yes.
that what you're telling me? Over a 20-year period, you paid approximately, if I believe it, because you don't have receipts for that, approximately $1,900.
That is correct.
Okay. Well, what your statement is, sir, is that they agreed to sell you what for how much?
Okay, it was...
I just want to hear.
Okay, it was the 2 cages, the outdoor aviary, the perch, and then there was miscellaneous bowls and like...
For how much?
1,000.
Look at me.
1,000.
Okay. And you took the perch, and you took the 2 cages.
Yes, ma'am.
And you paid nothing.
We agreed to do payments.
Well, you agreed to do payments, sir, because you came to pick up the stuff with no money.
Well, our agreement was...
You came... No. Was your initial agreement that you were going to make payments? Or did you come to pick up the cages with just no money and say, I'll make payments?
No, our agreement was to make payments.
Okay. You picked up the cages, the 2 cages and the perch, in what month?
It was November.
November of 2019.
Yes, ma'am.
And how much were you supposed to pay each month?
At first it was $200, and then with everything that was going on with my
No, not everything. Just a second. When you picked up the cages,
it was supposed to be...
how were the payments supposed to start? Is not an answer. In December.
I believe following month.
That's December.
Yes, ma'am.
Did you pay the $200 in December?
We didn't. She said 100 would be sufficient.
No, just a second. You didn't. Did you call her and tell her that you couldn't make the $200 payment? Did you call her?
Yes, I did.
And tell her that you couldn't make... You did. Yes. Did he call you?
Yes, after I contacted him via text.
Okay, so you contacted him.
Correct.
On what date did you contact him?
The contract was signed November 17th, 2019. And then...
Do you have a copy of the contract?
Yes, I do.
May I see it, please?
And I take that back. Trent did call on November 21st, and he claimed he was unable to make the first payment due to his daughter needed braces and he had too many bills.
Judge Judy continues in a moment. And later today...
Before you try to sell it to anybody, clean it. You know what I mean?
Yep.
Real cases, real people are suing Trent Bergeron for failing to pay for 2 bird cages.
Now, he's just a scammer. He just scammed you, is really all. He owes you $800. He paid you $200. He agreed to pay you $1,000 for all of them. That's what he owes you. You're not supposed to do that to nice people, sir. You're not supposed to take the property that you don't intend to pay for. We're done. $800, judgment for the plaintiff.
Right. This case is concluded. Parties are excused.
Money's hard to come up with these days.
I feel it was very fair.
We tried bringing back the cages.
They had a passion for birds, such as we did, and we would work with him as best we could.
It's over.
I am sorry for them, but it has to do with integrity.
And now, the next case.
All parties in the matter are Roberts versus Bamberry. Step forward.
Jessica Roberts is suing her ex-fiancé, Tim Bamberry, for the return of the engagement ring. Jessica claims she was the one who paid for it.
Miss Roberts, You and the defendant were engaged. The engagement didn't work out. Some convoluted story that the ring that was purchased, which I assume is in that box, which was your engagement ring, was purchased and your credit card was used. When you broke up, the ring went with Mr. Bambury, and you want him to pay for it.
Somewhat.
Well, you don't want... How much was the ring?
Total, I think it was $3,500.
Not around. How much was the ring?
It was 35 something. There was... I don't have... It doesn't show me the total amount here. It just shows me the last balance. It's $958.81. That's what's left. He paid most of it.
He paid most of it?
Yes.
So then let's talk about this. Let's talk about what an engagement ring is. Let's say he bought the engagement ring and you say he paid most of what it is.
Right.
You now have it back, right?
Yes.
And that's what I would do if you bought the ring and she kept it. Let's say you put the ring on your credit card, sir, and you broke up and she refused to give you back the ring. You would sue her and say, I want the ring back, right?
Yes.
Because I bought it and I paid for it. You have the ring.
Yes.
She doesn't want to get stuck with this $958. Do you want the ring back?
Yes.
Then you have to give her back the $958. That's very simple.
Judge Judy continues in a moment. Closed captioning sponsored by... Have you been cheated? Go to judgejudy.com. Like us on Facebook and follow.
Engagement ring is given in contemplation of marriage. The marriage doesn't come off for one reason or another. Person who gave the ring gets it back. That would be you, but you got to pay for it. Then the ring is yours. You can sell it, recoup whatever you can get from selling it to a private party. Can I see the ring? Just because I'm a little bit of a yenta.
It was designed for me. It was the salespeople that talked me into getting the credit card.
It's very pretty. Before you try to sell it to anybody, clean it. You know what I mean?
Yep.
Needs a good cleaning. Okay, anything else you want to tell me? Perfect. Judgment for the plaintiff in the amount of $958. That's all. Give him back his ring, Bird. It's his.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
You took the sneakers and then claimed they were fakes.
We did a UV light test, which is an indicator of them not being authentic.
Sometimes you're the windshield and sometimes you're a bug.
Judge Judy.
I just wanted the ring paid off. I wanted no more ties to each other.
Well, I was hoping that, I could at least try to recoup some of my losses.
We just couldn't communicate with each other to come to a resolution.
Probably because we still were kind of, and we just got back in each other's faces, kept yelling and screaming.
We broke up because we fight too much.
It just wasn't meant to last, I guess.
Very whirlwind. We were engaged a month after we met.
It was unbelievably fast and good.
We were broke up 2 months later.
Live and learn. Just take my time next time I fall in love.
Take it a little slower next time.
Take it slow. Don't rush into things anymore.
You're in the sneaker collection business.
He spent hundreds for a high-style pair.
We both agreed for $550.
Did you have them authenticated?
I did not have them authenticated.
You took the sneakers and then went home.
But he didn't watch his step.
You claimed they were fakes.
We did a UV light test, which is an indicator of them not being authentic.
Sometimes you're the windshield and sometimes you're a bug.
This is Judge Judy. 20-year-old Leonardo Franco and his brother Alonzo are suing Ryan Padilla for allegedly defrauding them regarding the sale of tennis shoes.
Judges, case number 161 on the calendar in the matter of Franco versus Padilla. Parties have been sworn in. Have a seat, gentlemen.
Thank you, Bird. Mr. Franco, you and your brother are collectors of this a long time. This is probably the second or third case that I've heard of people who collect these unusual sneakers. Just for my own information, I don't think I've asked before. What makes these rare sneakers?
Well, what makes them exclusive is basically because of the low amount of stock that's in them. See, Jordan and Off-White had a collaboration, so a lot of people, they admire both of those brands.
Jordan and Off-White, are those two brands?
Yeah, they're two different brands. Off-White being a designer brand, Jordan being, the Jordan, the Jordan shoes. So they have a collaboration, and they release little pictures and snippets of the shoes. People desire them, and they hype it up, which is basically just a lot of people wanting these shoes, and the fact that they come out with such little quantity and such mass of want for them. It just drives
advertising.
Yeah, right.
All right. Okay. How long have you been a sneaker collector?
Well, me personally, only really just a year. My little brother's actually the one that got me into it. He's been the one that's just been around sneakers basically all his life.
Okay. So, Mr. Franco, how long have you been a sneaker buff?
I've been into sneakers for about, I would say, 8 years. My older brother, he would also collect sneakers, and I've just been following him ever since.
How long have you been purchasing them?
Since I was younger, I've never had money to buy my own, but lately I have been able to afford my own sneakers.
So for the past year. And in the past year, how many pairs of sneakers have you purchased on your own?
I would say about 20.
When you've purchased the 20 pairs of sneakers, what have you done with them?
Just collect them. You don't want to wear them too much every day.
So you keep them?
Yeah. You pick selected days when you want to wear them because, for example, you don't want to ruin them. So it's very rare when you wear them. But yeah, for the most part, it's just kind of collecting them, wearing them every now and then.
How do you earn the money to buy them?
I sometimes buy it, and sometimes people do want it. So if I don't particularly like it, or if it's not in my size, I sell it to people, obviously for more than retail because of the hype. So many people want it. And then from there, the money that I collect, I can pick and choose which ones I want to buy.
So you do, in fact, sell some of the sneakers that you buy?
Yes.
So you're in the process of buying and selling?
Yes, ma'am.
Now, when you sell them, how do you sell them? Do you put ads online?
Yeah, you can do it many ways. There's third-party sellers that they take fees as well, but you can also try to sell them yourself and post them up yourself.
Okay. Alonzo, let's stop for a moment. You buy a pair of fuchsia green sneakers.
Yes.
And it's not your size, but they're unusual. You pay $500 for them.
That's for resale.
You decide to sell them, and you want to go to a third party. How do you get this third party?
You post it up on their site, so you send them to the third party, and then from there, they authenticate it and legit check it. Once it's been authenticated, they send it to the person who has bought it.
Okay, so the third party buys the $500 sneakers from you. They authenticate it. If they don't authenticate it, can they send it back to you?
Yes, that is right.
Now, when you sell it to the third party buyer, how much do they pay you for it?
Every shoe depends.
This shoe that I just described, $500, not your size, very, very funny shade of green. How much would they pay you for it?
Well, for retail, this shoe retailed around $220. $500.
Not retail. I'm asking you what the third-party buyer would give you for it.
Around $500.
So the same thing that you bought it?
Well, these weren't to buy to keep.
Alonzo, I want you to pay attention to what I'm saying to you. I want you to take the sneakers that are on the table and put them on the floor. Take the sneakers that are on the table, put them on the floor so we don't get confused. Now we're not confused. Now we're talking about a pace. And you sell them to a third party. You purchase them for $500. How much does a third party broker pay you for the sneakers that you've paid $500 for?
Around the same.
Not about. You can't sell them for the same price that you paid for them. You don't make any money if you do that. Don't you understand that?
Yes.
Is it all right if I step in and help him out? Because I feel like he's just a little confused. Basically, so let's just say
unconfuse us. You pay $500 for ugly green sneakers. You want to sell them to Phil. You put an ad on whatever site you sneaker people go on, okay? And what do you sell the $500 shoes to Phil for?
It's whatever someone is willing to put up. When you sell through StockX, you don't sell to a specific person. You kind of just put up an offer saying, hey, I'm willing to sell it for this much, while someone else is saying, okay, but I'm willing to only spend this much. So you can either keep your ad up for your price, or you can just accept the bid. It always fluctuates. It's never going to be the same, basically.
Yeah, all right. It's very confusing to me in business. Who's this third party? What does this third party do?
When, let's say, I sell a shoe, I send it to them, and all they're doing is making sure that the shoes that I sold them are, in fact, real, authentic, and they're not fakes. And once they've authenticated...
And how much do they get for doing that?
They get 8%.
For $500, you pay somebody 8% to authenticate them. And once you get them authenticated, you put up a bidding process and you say, all right, I have these sneakers, I want $900 for them. At the appropriate time, or I went $800, and then somebody says, I'll give you $8. Is that what happens?
Yeah, exactly.
And when you put up the ad, do you put up in the ad that they've been authenticated?
Everything on that you sell through them has to be authenticated. They don't sell anything fake.
So they actually, for 8%, sell the sneakers?
Yeah, they're basically selling, or sorry, they are selling it for us.
Okay, so you sent it to a third party, and they sell it to you, and they take 8% off the top of the price that they get for the sneakers. Is that correct?
Yeah.
So you sell your sneakers that you buy by sending them to a company whose business it is to authenticate sneakers, and then they sell your sneakers and say to you, I got this bid or I got that bid, do you want to take it or not? Is that correct?
We control how much we want to sell it for. So, for example, if I were to have a pair of Jordans and I just go on their website and say, okay, I want to sell it for $280, someone buys it, okay, now I send it out, then they authenticate it.
I understand. All right, this is the case. You bought a pair of sneakers from the defendant and claimed they were fakes. That's the case, right?
Yes.
Yes.
Okay, so now that I know how you run your part of the business, because you're also in buying and selling, tell me how you found this pair of sneakers.
So we found this on OfferUp, which is just a place where you can also buy and sell, but that's more private seller. There's no middleman or anything. You just meet up with them and you either buy it or sell it.
Just a second. So you bought through
OfferUp.
That was private and no middleman to authenticate. And when did you see the ad?
We saw it on November 8th of 2020.
Do you have a copy of the ad?
Yeah, I do right here.
I'd like to take a look at it.
So that's just the main screen. I don't know if you'd like me to just swap the papers to see all the pictures.
No, I would just like you to show me the ad that you saw that drew you to the sneakers.
It's this one right here.
Jordan 5 Off-White, size 11, Rialto, posted one day ago. Ryan. Who's Ryan?
That's me.
And when did you go to see the sneakers?
Yeah, I texted him, and we both agreed for $550. He sent us his address, and we just went over. We will try to authenticate.
Okay. And your brother went over to Ryan's house?
Yes.
And he showed you the sneakers?
Yes.
Did you ask any questions?
Well, we did, like, stuff, but it was more of, like, chit-chat. We didn't really ask him much about the sneakers itself.
So you just looked at the sneakers, you had agreed on a price of $550, and you paid him the $550?
Yes.
Did you get a receipt?
At the time, no. But once we arrived home...
That's what I asked you. At the time, you gave him the $550 and took the sneakers.
Right.
The deal was concluded.
Right.
Am I correct?
Yes.
Okay. And then you went home on the same date, November 8th.
Right.
And then what did you do?
So at that point, we noticed that he had a receipt in the picture, but it wasn't in the box. So we texted him saying...
Okay, let's put on the picture again, please. Okay. Now, that's what you bought. You bought the sneakers. And show me the receipt.
Okay.
Point to the receipt.
Basically, you can see it's like right here, but I do have another picture that shows it just shows the picture. I don't know if you want me to pull that up.
No. You're talking about that little piece of paper over there on the side of a box?
Yeah.
Point it exactly with your finger. That's a box.
Yeah, it's the box right here.
You're talking about that receipt.
That white, I guess, thing you see next to the box.
Right, that little piece of white paper.
Yes.
Okay, so now you go home, and what happened?
So I texted him to ask him for the receipt, and he just wasn't responding. So we started getting a little, I guess, worried at that point. We're like, okay, let me do a black light test, because we did have a UV light test. So once we brought the UV light out, shined it on the shoes, it started glowing. Basically, the stitching on the shoe started glowing, which is an indicator of them not being authentic, because they're not supposed to be glowing.
Let me ask you this question. How big is this blue light?
Oh,
this light?
It's a flashlight. It's like a flashlight, basically.
It's a flashlight?
Yeah. It's this one.
Oh, that you could take with you to the defendant's house, and you didn't.
Yeah, it was my fault, because I just simply forgot it.
But we're just putting together the story.
Judge Judy continues in a moment.
The only way that you have any possible way of winning this case is to show me that he found out they were fakes.
Does it matter if he himself said that they were real?
Don't tell me it doesn't matter. Don't tell me it doesn't matter.
Closed captioning is provided by Leonardo Franco and his brother Alonzo claim Ryan Padilla sold them an allegedly counterfeit pair of tennis shoes.
So far, you're in the sneaker collection business, you and your brother, for a long time. You both buy and sell sneakers, and you keep some that you like very much. In this case, you did not go through a third party. You went to a private party with sneakers that had not been authenticated. You went, you saw the sneakers, you looked them over, you took the sneakers, and then went home. And then you took your flashlight and flashed them on the sneakers and said, oh, this is not the right color stitching. It's an indication that they're fake. So you called him.
Yeah, I texted him.
And what happened?
At first, I just texted him for the receipt. He just left me on red, like he didn't respond at all. So then that's when we decided to take it to actual authenticators just to get 100% knowing that these are fake, which are my witnesses here. We took it to their store. They saw the shoes and just pointing out many different reasons as to why they were fake. And at that point, we text them and say, hey, if you don't give us our money back, we're just going to have to, whatever we did in the 24-hour period of us having the shoes is up to us. What he sold us were real shoes, and basically, like, that's that.
I'm going to hear what he has to say.
Right.
But he's right. That's that. Okay, now we're up to you. Where did you buy the sneakers from?
I bought them off the same site, OfferUp.
When did you buy them?
A few days before. I have the receipt, how much I paid for them, if you want to look at that.
I do.
I paid $400 for them on November 9th.
Well, that just shows a withdrawal.
Yeah, it was a withdrawal for the shoes.
Well, that doesn't tell me where it went. So what you're telling me is you bought them a couple of days before.
Yeah.
Not yeah. This is a court. Yes, yeah.
Yes.
You want to say yes,
Yes, Your
twice,
Honor.
you can say yes. Perfect. Even better. Even more perfect.
Judge Judy continues in a moment.
I am taking for granted that these sneakers may not be authentic. You had the possibility of authenticating them. You chose not to do that. You completed the sale. So sometimes you're the windshield and sometimes you're a bug.
Real cases, real people. Judge Judy are accusing Ryan Padilla of selling them an allegedly counterfeit pair of tennis shoes.
How long have you been in this sneaker selling business?
About 6 months.
Do you know about this third-party authenticator?
Yeah, I also purchased through Go and StockX.
Great. These sneakers in question, did you buy them through a private person or through an authenticator?
Through a private person, Your Honor.
Okay, and the name of this private person?
It was Jay.
And did you go to Jay's house?
Yes, similar to what they did.
Okay, and you paid him $400 for the sneakers?
Correct.
Did you have them authenticated?
I did not have them authenticated.
Did you have a blue light with you, similar to the ones that the plaintiff described?
Yes, that's what I was going to say earlier. I had a blue light at the house, and I actually let them use it on the shoes, so...
Nope, he did not.
Did you take the blue light when you brought it to Jay's house?
Yes, I did.
Did you use the blue light at Jay's house?
Yes, I did.
And you still gave Jay the $400?
Yes, I did.
Were these shoes in your size?
No, they weren't.
So you were buying them to resell?
Yes.
When you put them on for sale for $600 and you settled, so that means you made a quick $150.
Yes, Your Honor.
Perfectly fine, entrepreneurial way to do business. Let's go successful, Mr. Franco. In my judgment, which is the only one that counts here, is if you had evidence that he knew, and the only way he could know was taking them to an authenticator who advised him that they were fake sneakers. Your contract with him was concluded when you went to his house. You were certainly not restricted in any way from inspecting the shoes. The ad for the shoes did not indicate that they had been authenticated by any company. That says...
That doesn't matter if he himself said that they were real?
Don't tell me it doesn't matter. That's called puffing. This is the ad. You are not a naive buyer. You both buy and sell sneakers in a very sophisticated fashion in order to make side money, which is exactly what the defendant does. This is a strictly contract sale. You went, you saw them, you actually had the capacity to take your flashlight with you and shine the light on, which might have given you a clue that, I'm not sure these are real. I'm going to have to take them to an authenticator. You could have done that, but you didn't. You took them home, you negotiated a price, you went and saw them, you said, I like them, you took them home. Now, the only way that you can demonstrate to me that you have any possible way of winning this case is to show me that between the time he says he bought them and the time he sold them to you, he found out they were fakes.
Judge Judy continues in a moment. Closed captioning sponsored by Real Cases, Real People. Judge Judy. Are you the victim of a scam? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Now, the only way that you can, I'm going to say it again, demonstrate to me that you have any possible way of winning this case is to show me that between the time he says he bought them and the time he sold them to you, he found out they were fakes.
Well, the only way
and you can't do that. Your contract is concluded. I don't need to speak to an expert. I am taking for granted that these sneakers may not be authentic. That's your problem. You had the possibility of authenticating them. You chose not to do that. You completed the sale. So sometimes you're the windshield and sometimes you're a bug. Today you were the bug. We're finished.
Thank you.
Parties are excused. This case is concluded.
And on the next Judge Judy.
The pet that you decided on was a tortoise.
We took her to the vet. That's when they told us that she had pneumonia and she was too far gone.
Do you remember any of the tortoises getting sick?
Judge Judy. I invited them to my house, so they're comfortable with coming over and authenticating the shoes.
I'm not a shoe authenticator, you know. I'm just a normal guy just trying to buy some shoes that I like.
I let them spend as much time with checking out the shoes as possible, too, and they were there for about 30 minutes.
Yeah, that's why I thought they were legit, but when we did the test, like, they are fakes. Like, the shoes are fakes.
I did. I had one on the side of the mantle for them if they wanted to use it, so.
Basically, if you were to shine your a black light onto a shoes, the stitching on the shoe itself is not supposed to glow.
I told them if you would like the black light, it's right here for you to use.
But if it starts to glow, that just shows that they're coming from, well, not from Nike itself.
A lot of people right now are struggling, so they would like to make more money in any way they can.
I can't resell them now just because, I mean, well, that's illegal.
I sold authentic shoes.
That is correct.
She was eager to get her new rental on the market.
You have to pass certain inspections.
Right.
Her tenants say it was a death trap.
They moved into a house. They couldn't stay there. There was a gas leak. They had to be evacuated to go to a hotel, and they almost all got killed. Put your hand down. Does it look like you're losing?
This is Judge Judy. 22-year-old Abigail Bosco, 24-year-old Breanne Jones, and 23-year-old Simon Becker are suing their former landlord, Annette Malveaux, for the return of rent and their security deposit, as well as reimbursement for hotel costs.
Judges, case number 191 on the calendar in the matter of Bosco, Jones, Becker versus Malveaux. Parties have been sworn in.
Who is going to speak for the plaintiffs?
I will mostly be speaking for the plaintiffs, Your Honor.
Tell me your name.
Abigail Bosco.
Miss Bosco, you and your friends rented a house from the defendant. There were several issues. You want your rent and security back. Your rent and security together form the maximum of this court's jurisdiction, which is $5,000. There is also a request for reimbursement for hotel costs. I wouldn't even have to reach that if I found that you would be successful in your lawsuit to retrieve both your security deposit and take any information from you. I want to get some basics from Miss Malveaux. Miss Malveaux, you're in the real estate business, or do you dabble in real estate as a hobby?
I have a business in real estate, yes.
How many homes do you own?
5.
Did you purchase them or did you build them?
The present ones I have, I purchased. The property that we're speaking of was a tear down and build. I developed it up again.
You are aware of the fact that in most jurisdictions you cannot occupy a home unless it has a certificate of occupancy by the county where the home is located. You understand that?
Yes.
When you leased the property to the 3 plaintiffs, did you in fact have a certificate of occupancy?
Yes.
I'd like to see it.
So I have the clearance.
No, don't say anything. Just put up the C of O for the property that the plaintiffs leased, because it was a new build. On what date now, Ms. Bosco, on what date did you rent this house?
We moved in July 15th.
And on what date did you sign the lease?
Approximately July 1st.
Now, I want to see the C of O for this house.
Okay, so I hired a property management company.
I don't want to hear anything from you other than either I have the C of O or I don't have the C of O.
No, I do not.
Do you know when one was finally issued for your home?
No, I do not know the exact date.
What's the name of the management company that you hired?
One Rent.
Who owns this house?
I do.
Miss Malveaux, they're going to get their money back. Because if you can't produce a C of O for me, everything that they say is accurate. They moved into a house. They couldn't stay there. There was a gas leak. They had to be evacuated to go to a hotel. They want their rent and security back, and they're entitled to it. Do you understand? Now, do you want time to get me a certificate of occupancy that allowed you to rent this property to people on July 15th, 2020? Do you want time to get that? Or don't waste my time? And if you don't have that document, I'm awarding them their $5,000 because they gave you $2,500 security deposit and $2,500 for the first month rent, and they almost all got killed with a gas leak. Put your hand down. Does it look like you're losing? No. Don't be stupid. Do you understand me? Now, do you have a certificate of occupancy? Is there one in existence that starts?
Yes, there is. I'm not sure if you understand.
Then go get it. If there is, then go get it. We'll wait.
Am I supposed to drive home? I'm not understanding.
I don't care what you do. You're coming to court today. This is not coming to a beach. This is not coming to a garden club. You were coming to court. You're coming to court on one house, the only house that you built. Every other house you bought and refurbished.
I
this
didn't
was a tear
build
down
the
that you
house.
built.
I'm not sure if you understand me, Your Honor. Okay, I didn't build the house. Okay, the house originally was a built house. It was a 2-bedroom, 1-bath. It was renovated into a 3-bedroom, 2-bath.
Let me understand something. And I wish I had a reporter here to read it back to me.
Okay.
You said it was a tear down. Those were the exact words that you used.
Okay,
it was
my
a tear down.
apologies. Okay, I'm sorry, Your Honor. Okay.
What you mean is it was a total renovation.
A total renovation, yes, ma'am.
And a total renovation add-on. Then you needed approvals and a certificate of occupancy.
Correct.
And I want to know whether or not you had approvals and the certificate of occupancy, because before you get a certificate of occupancy, you have to pass certain inspections.
Right.
And my sense is those inspections were not done before they moved in.
Yes.
Well, then I have to say that you're not a very smart businesswoman, and I would have thought that you were a smart businesswoman because you own 5 properties that you rent. You understand dealing with escrow. You're coming to court today because 3 people said that they almost got killed in your renovated tear down because there was a gas leak in the house because it wasn't inspected. And you said, I have the inspection papers, but I don't have them with me. Well, I have to say that that's somebody who's not prepared.
I have the clearance of the inspection that was that the property manager completed with the inspectors. That's what I was trying to put up.
Date?
I mean, it's a full package.
On what date did the county inspectors give you the right to go into the house? That's all I want to know.
This is the report.
What's the date of the report?
And it's Let me just hold on.
I'm not interested in a report from the company that you hired.
I understand
I'm
that,
interested in a report from the county.
It was basically all this was done consecutively at the same time. So in this report, it states...
I don't know who that report is from.
Well, Your Honor, I hired a property management company so that...
Then you should have that property management company with you as a witness.
And I tried to bring the property management company with me. And the property management company should be here.
Right. Well, you're absolutely right.
Yes.
And that was your obligation. Judgment for the plaintiff. You gave her $5,000 to $2,500 security deposit. Is that correct?
It was a $2,900 security deposit and a $2,900 rent fee.
Judgment for the plaintiff in the amount of $5,000. We're done. Thank you.
Thank you, Your Honor.
Case is concluded. Parties are excused.
I definitely feel I wasn't prepared.
We have been at our wits' end trying to every method possible to get our money back.
I'm just glad it's finished.
I'm very ecstatic about her decision. This has been a long time coming.
All parties in the matter of Garcia versus Murphy. Step to the podium, please.
Travis Garcia is suing his former roommate, Richard Murphy, for money owed for rent, utilities, and their security deposit.
Mr. Garcia, you and the defendant met each other in a sober living facility. In what year was that?
That was in 2018.
Were you in the facility at the same time for any extended period of time?
Yes, we were. We actually shared a room from, I believe it was like October, November, December of 2018. I moved out January 2nd of 2019 into rented a room with a private homeowner.
When you rented that room, is that the first place that you allowed the defendant to...
Let him stay from time to time because he was having a hard time.
And when you let him stay, you understood, because I've read his papers, that his source of income was Social Security disability.
That's correct.
And did you know how much he received from Social Security disability every month?
Don't recall at the moment, but I know that it was enough for us to afford an apartment of our own.
Just a second. How much do you receive from Social Security disability?
$17.63 a month.
And that's because you injured your back?
Neck, back, yes.
This is your complaint. The two of you decided to rent an apartment together after living together for a while, and it is your claim that during the period of time that you lived together, you advanced him money and stuff for his share of rent or utilities or if he needed cash, and you kept a ledger of that.
I did, Your Honor.
Something happened in May, and at that time, the defendant left. What happened in May that caused him to leave the apartment?
I actually discussed a 30-day notice once he paid rent in June because he had, for 10 months, the last actual 9 months, he had been paying his share of the bills. But when we moved in together, I put down the initial rent, the deposit, basically I covered everything for us to move in together. Let's check. And none of that money went towards me. And at that point, I didn't see any effort of paying me back the sum that he owed from missing rent and his bills. And
well,
so I gave him 30 days.
You mean for the security deposit where you are and first month's rent. What was it that you paid for? You paid for security deposit and first month's rent. And he did pay his rent.
He started paying,
and
he missed 2 months.
He did pay his rent.
He didn't pay his rent in the first month.
He didn't pay rent the first month because moving in, you paid both first month's rent and security.
Yes.
I believe you. The security, you'll get back.
He got it all back.
I assume. Just as a... Great. Even better. So now we're talking about the first month's rent.
I received 200 of the 500 back.
That's your problem. Deal with the landlord.
Judge Judy continues in a moment.
What is that you're showing me, Mr. Garcia?
These are the payments that I did receive from him from April 2019 through July 2020.
Let me explain this to you, sir. I don't care about your ledger.
And later today...
You don't have anything to say, do you?
Not as of right now.
Well, now is the time.
Travis Garcia claims for rent, utilities, and their security deposit.
Okay, the full rental on the apartment is how much?
$16.75 a month.
And how much was the defendant's share of the rent?
Half.
Was half. Did you, Mr. Murphy, be clear, did you pay the first month's rent that you moved in?
No, I did not, and he understood that.
Great. I don't ask what he understood. Did you pay it? That's
No.
a yes or a no?
No.
Great. $837.50. What other month do you claim? By the way, how much of a stimulus check did you get in May?
It was the first one. I got $1,000. There was no discussion with giving him any of that money. I just gotten out of the hospital for 36.
Just a second. Don't care. Okay. I don't care. That's what he's annoyed at. That's what he's annoyed at. And the truth of the matter is, you live together. It was your share of the rent. You didn't pay the first month's rent. So that's $837.50. Now, what else do you think he owes you, sir?
The rent from August, the rent from September, and all the cash that I had advanced him.
Forget cash. I'm not interested in cash. August and September. Did you pay August's rent, sir?
I don't have August, but I do have September. You'll see where I've highlighted.
May I see it, please?
Yes.
When did you move in?
Okay. Can you see the highlighted?
So in September, well, I see highlighted where you took out cash withdrawals, but I don't see what you did.
Yeah, everything was done in cash, Your Honor. If you can see where it adds up.
That's $900.
Yeah, because I paid a little extra towards PG&E, cable, and on the other ones I've got, it shows that I paid him $1,200 a month, but that covered my half of the rent, PG&E, cable, and still gave him a little bit of money.
What do you want to show me for August and September, sir? So far you don't have August's rent.
No, ma'am.
Okay. What is that you're showing me, Mr. Garcia?
These are the payments that I did receive from him from April 2019 through July 2020.
Let me explain this to you, sir. I don't care about your ledger.
Okay.
Right now, he doesn't have proof of payment for August. He acknowledges he didn't pay the first month. He has proof of September, 1674. Judgment for the plaintiff. We're done. Thank you very much.
Okay, thank you, Your Honor.
Bye.
This case is concluded. Parties are excused.
I think it was fair.
I guess it's better than what I anticipated getting if I had not come here today.
I guess he needs money.
It's unfortunate. You try to help some people, and it just doesn't work out sometimes.
And now, the next case.
All parties in the matter of Gadziak versus Tubbs. Step forward.
25-year-old Zachary Tubbs for an unpaid car loan, as well as unpaid rent and utility bills.
Ms. Gaziak, the defendant was your boyfriend. You lived together. You shared an apartment together, and it is your claim that now that you have broken up, you're no longer a couple, that he owes you for rent and a car loan. Mr. Tubbs says that you were a couple, you lived together, lost his job, looking around for something else. You covered the bills. He would have done the same for you. You were a couple. That's your defense.
No.
Sounds right to me.
Judge Judy continues in a moment.
I just want to let you know that as smart as the two of you think you are, Bird's smarter.
Real cases, real people. Judge Judy. 25-year-old Elizabeth Gadziak is suing her ex-boyfriend, Zachary Tubbs, for an unpaid car loan, as well as unpaid rent and utility bills.
How long did you live together?
We did a 10-month lease and we did a 4-month lease. We were actually on 2 leases. I met him about May, June, and then we moved in together when my lease was up September, the beginning of September.
Now, when you moved into a place together, were you both on the lease?
We were.
And when did he lose his job?
He was going between a couple, the restaurant, and...
I don't care where he was working. Let me ask you the question, Ms. Gaziak. What do you think happens to a married couple that rent an apartment together, and let's say the wife loses her job? What do you think happens?
The other person helps out.
Picks up the slack.
Yes.
Well, what you were doing is really nothing more than playing house. You're not married. You took an apartment as if you were a married couple. You signed a lease, both your names, you shared a bed together, you talked about future together, just like a married couple.
Well, our difference is that we went into it knowing that we were going to work together, and we were doing great for the first 3 months. And when we broke up, he did find new opportunities. He didn't go without a job for very long. He went a little bit, but he got a job pretty quick after. And at that point, we were not together. For most of the time we were living together, we were not actually a couple.
I don't know what most of the time means.
We broke up in December, the late December, beginning of January 2013. So from January 2013 all the way until the end of the second lease, which was November 2013, we were not a couple.
Then you shouldn't have been living together.
I agree, but where our situation is different is we kind of worked as roommates.
I don't buy that at all.
Not as of right now.
No.
Well, now is the time.
Judge Judy continues in a moment. Closed captioning sponsored by. Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Mr. Tubbs, is what you're telling me that you don't owe her any money?
When we...
What does an mean, Mr. Tubbs?
When we first...
Yeah, Mr. Tubbs.
Started...
Mr. Tubbs, if you're going to tell me that you agree with her that you owe her money, I'm going to throw you both out of here. Do you understand?
No.
Do you understand?
That's not what I'm saying.
That's what I'm doing. I just want to let you know that as smart as the two of you think you are, Bird's smarter. Okay. Do you understand?
Okay.
All I want to know from you is, do you still have the automobile that was purchased with her $1,000 down payment?
Yes.
And when she gave you the $1,000 down payment, did you have a discussion about paying her back that $1,000?
I let her know that it wasn't going to come all right at once, and there was no way I could just hand her $1,000.
But you agreed to pay her back?
I agreed to help her, yeah.
Well, you agreed to help her, not help her.
Because she
helped you.
Yes.
You agreed to pay her back. Did you give her back any of that money?
At the time, so I don't have, like, records of it, but I was giving her cash.
How much?
I was giving her a couple hundred here and there, as much as I could when I could.
And is that in addition to contributing to the rent, or is the rent something completely different?
I believe the rent and everything else would be different, but on the second lease, I
forget about rent. I don't think you owe her a penny with regard to rent. Nothing. I'm just talking about the $1,000 that she gave you. I assume that you have proof of. Is that right, Ms. Gasniak?
Yeah.
Okay. That she gave you so you could buy a car that you still have, and you're no longer a couple.
Yes.
Is that right?
Yes.
Okay. So that you have to pay her back.
Yes.
Good. Judgment for the plaintiff in the amount of $1,000. That's all. Thank you.
Please excuse me. Step out.
Judge Judy continues in a moment. And on the next Judge Judy.
We just got at each other's throats, you know. He had some issues that he needed to take care of, and I was trying to help him out, and it just didn't work.
I was not making as much money.
We worked well as roommates, you know. I was just trying to help him out. He was in a tough spot. I had trouble making my rent.
It just wasn't working out.
I knew if we worked together, we had 2 different rooms, it would work financially for both of us.
We decided we worked better as roommates.